Hi, everyone. Welcome. As a reminder, we do ask everyone to turn their cameras on. I am seeing quite a few cameras off, so if you could just take a moment to please turn your cameras on before we start, that would be awesome. I'm really excited to introduce Alex Civetta here today from Mintz Levin. We're doing a session today on company formation and co-founder agreements, which are really huge for early stage founders. Alex is an expert in all things entrepreneurship, and really excited to introduce him to you today. So thanks, everybody. And now I will turn it over to Alex to get started. Thanks,
Okay,
Alex.
wonderful. Thank you so much. Good morning, everybody. I take it, can you all see one another on this, or can you only see me? I forget how it works. Just wave if you can see one another, and if nobody waves, I assume you guys can't. Okay, good. So I see some, maybe, yes? Okay, good, wonderful. So you can see we've got a relatively small group. There's maybe 20, 30 of you, which is actually kind of a good thing. So we can keep today somewhat conversational. We're going to be going through 90 minutes worth of content and questions and answers around some of the basics of starting a company and focusing particularly on co-founder relationships, one with another, and the role of the entity and the role of the individuals and the different kinds of agreements that you all, as you start your companies, will end up signing and negotiating with one another and with the entity. So that's the purpose of today's session. As you probably know through a mix of introduction and Google stalking, my name is Alex. I am at the law firm Mintz. We're here in Boston. It's a global law firm. And I focus my practice almost entirely on high growth companies from formation through exit. So I've been in practice about 10 years. I've been a lawyer in residence here at the Rock Center for the last probably 2. And I teach workshops and courses about this kind of subject matter across Boston and across the country now and again, right, in programs like this. So I'm very pleased to be here and speaking with all of you. We probably have slightly too many people to go around and do a full set of introductions. But I assume since you guys are part of the cohort, you guys have some familiarity with one another and some of the businesses that you're thinking about founding or in the midst of founding. And as we go through the program, trying to keep it conversational, we'll probably speak with some of you about particular examples that you've got and questions that you may have to try to keep things a little more conversational and lively. Sound good? Okay, excellent. So I started this off with this concept of a parking lot here in the corner. 90 minutes is a good amount of time, but not a huge amount of time. And we may find that you ask a question or you have an insight or have something you want to talk about that I'm going to get to later in the presentation, or where I think, look, let's handle this and consolidate it with something else that I want to talk about a little bit later on. So, keep me honest here. I want to put it up here. If I don't end up answering your question or say, look, we'll talk about that later, I'm going to write it down to make sure that at the end we can go back through and hit everybody's questions. If you have a question as I'm going through and you have a subject matter you want to talk about or example you want to bring up and you don't feel like it's relevant just yet, write it down in your own margins because we will have plenty of time at the end to come back and talk through examples. I often find that some of the best learning we can all do and conversation we can have is in reference to a specific example that somebody might have, because oftentimes a question you're thinking about asking is a question somebody else has also got, right? So definitely don't be shy about doing that. I'm aware, as you guys can probably see all around us, there is a huge suite of technology tools available to us to do this, one of which is a very cool way of raising hands and letting me see kind of who's got questions and whatnot. Please don't be shy about that. I know some of you are probably in time zones where it's early and you're just barely caffeinated. Take advantage of the coffee or the tea or whatever your drug of choice happens to be, or just the bright sunshine outside, or if you're somewhere where it's in the depths of night, thank you for joining us, Aditya. But please do try to jump in and keep things conversational because it's going to keep it fresh for everybody. It's only so interesting to listen to one person talk for a period of time. All right, wonderful. Without further ado, I'd like to get into it. Our agenda today is relatively brief because we do only have the 90 minutes. We're going to talk about entity formation, and we're going to do kind of a quick zip through that because I understand you all had a session on entity formations and choice of entity earlier in the summer. But we are going to hit a little bit of that because it's relevant to what we're going to talk about today. We're going to talk about capitalization, meaning ownership over the equity securities in the company that you're going to be forming, because that's going to be the bedrock of how we think about how the founders relate to one another, what Delaware law requires, and we'll talk about the glorious jurisdiction of Delaware and why we all choose it, and how that kind of those decision rights and those decision rules interact with each of your rights in the company, how the board works, how all of the different officer appointments work, and all of that. We're also going to talk about governance structure. So capitalization, sort of who owns which equity securities in the company, is the sort of precursor to the discussion around what rights do people have and how do you actually exercise those rights. I promise, even though there's a little bit of parliamentary procedure involved in that, we will keep it high level and keep it interesting so that nobody falls asleep. Then we're going to talk about agreements with founders. We're probably going to focus specifically on two agreements: the restricted stock agreement, which is where vesting, I'm sure all of you know about vesting to some degree, where vesting happens, and a couple of other things around ownership of your stock in the company. And we're going to talk about invention, assignment, and confidentiality agreements between the founders and the company. And finally, we're going to stop with some space, hopefully plenty of it, for questions and answers, because again, that's probably where we can take some of the stuff that we've talked about in the session and put it into practice as it applies to each of your businesses. Sound good? Okay, wonderful. I'm going to jump into forming an entity. And again, this is going to be fairly fast because I know you guys already talked about this with another group earlier in the summer. So we have an example. Well, I guess I'm pointing back, the monitor's up in the front for you guys. We're going to talk about an example company today. We call it SpinCo Therapeutics. I'm picking a therapeutics company. I'm picking SpinCo because we do a lot of work out of the ecosystem here, and a lot of my companies that I represent are companies where somebody takes some kind of cool technology somewhere, whether it's software or some therapeutic or some medical device, and they're going to spin it out of an academic institution. There's a whole separate session you could probably do, or you can definitely do, on licensing and intellectual property. We're not going to touch any of that today. This is purely about formation. So if you want to talk about those subjects, you drop me a line. We've got office hours. I'm happy to talk anytime. I practice in that area as well. But today, just as an example, we're just going to talk about kind of a hypothetical company with a group of co-founders. So I want to talk about contractual relationships. And some of this might be one-on-one for some of you, but for some of you, this might be new. Every once in a while, I have a group of founders who comes and meets with me, whether it's at the iLab over here at MIT, where they have an idea that they need to sign something that they think of as a co-founder agreement, meaning we all think we're going to go form a company. What do we sign with one another that's going to make it so that we can kind of form this company and do the things we want to do? How do we kind of establish decision rules and whatever else? If you have two co-founders, the concept of doing that it doesn't seem crazy to you, right? You just have to sign one agreement between the two of you, right? So like, Grace, if you and Ian want to form a company, you think, okay, can the two of us, Grace and Ian, sign an agreement that says, here's how IP is going to work, here's who's going to be on the board, and how we're going to run things, once we have this entity. The trouble is, obviously, once you get multiple founders, if you actually wanted to bind everybody in a series of agreements that makes it all work, you'd have to have a lot of different contracts at work, right? You'd either have to have a 5-party agreement, which is super messy for a variety of reasons, or you'd have to have a bunch of individual agreements, one with another, where if somebody isn't performing or someone isn't doing the right thing, your ability to exert rights, one versus the other, is puts you in sort of a personal bind with other, kind of other co-founders, one-to-one, in a way that isn't really helpful for anybody and can get quite complex. So instead, perhaps obviously to all of you, you put an entity in the middle. Each of you, when you are a co-founder, is going to be spending your effort, the crazy 90-hour weeks that you will all work as startup founders, if that's what you choose to do. Like, your guys' job is hard, no doubt about it. You're going to be pouring that effort, producing IP, building things for an entity. And so the fundamental exchange we're all talking about here between you as a founder and the other founders around the table is you contribute your effort to the company, and in exchange, the company pays you back in the form typically of equity for co-founders, and eventually, if you guys have cash, right? Even though at the beginning, my guess is for most of you, you'll be starting a company that has $0 in its bank account. Until you can get some seed capital, you're probably working for free, at least from a cash standpoint. And so putting the entity in the middle is the key, right? And so the agreements that we talk about today, when we talk about co-founder agreements, we're talking about agreements between a co-founder and the company. The co-founders should not typically be signing agreements between one another. All right, so what kind of entity you're going to choose, right? If we all accept the proposition that you should form a legal entity and you should form it early, well, actually, first things first, before I zip past that, can you give me, I'm going to try to use this thing. I'm going to use a yes-no poll. So can everybody give me a yes or no about whether you were in the session that happened, I think, last week or 2 weeks ago, about what the different types of entities are and why we might form an entity, just to know how deep I should go on this topic. Okay. So this to me suggests that we are about 50-50 split. About half of you said yes, about half of you said no. Slightly more said yes versus no. I can display this to the extent anyone cares. 53 to 46. How exact are we? Okay, great. So I'm going to spend probably a little bit more time talking about entity formation just to make sure we're all on the same page. So when you're thinking about forming an entity, generally speaking, you're thinking about one of three types of entities, maybe four, but for almost all of you, I'll kind of zip through to the conclusion. 99% of the time when you're forming a startup, it is probably going to be a C corporation, and it's probably going to be in Delaware. And that's we're going to kind of drive toward that answer. I just want to go through each of the different types because look, every once in a while there's an exception, right? We represent some companies where it's an LLC because there are good reasons for it to be an LLC because of its facts and circumstances. But most of the time you're going to be Delaware C Corp. So the reasons why you're going to incorporate, very quickly, probably the two most important things to think about. Number one, liability shield. So when you're out there in the world and you're doing things as a business, if Sebastian's out there and he's painting somebody's house, right, and his ladder falls over as he's painting and it smashes the person's car, Sebastian's the person who can get sued for that because he's acting in his personal capacity. But if Sebastian's got a painting company, Sebastian Paint Co. LLC, right? And that painting company has some assets and it's got some insurance and whatever else. When the ladder falls, the entity that can get sued is that painting company. That company is the one that has the assets, that's the one that's party to the contract with the homeowner, where it's not Sebastian in his personal capacity. They can't go after your house, right? They can't go after your bank account. It's the company's assets. So that's a simple example, but obviously for all of you, as you are going to probably be doing businesses that are a bit more complex, you can appreciate why when you take on, say, if Kenny is going to do something where you take on a bunch of material, confidential material from a university or a potential partner, if you do that before you've incorporated and you personally sign the material transfer agreement or non-disclosure agreement, and then you're tired so you leave it on the train, right? They can sue you personally. It's in your personal capacity versus it being a company obligation. So that liability shield is very important. That's one of the reasons why you form an entity. The second reason you form an entity is if we track back to these slides in the beginning, before you have an entity, when you are running around with your co-founders and everybody's like sitting at the whiteboard in the iLab like everybody does, and you're doing a jam session talking about all the different things you can do and the product features you might have, unless and until you have an entity, and unless and until all of you have signed founder agreements with the company, it's not at all clear when somebody generates IP or puts in an idea or contributes something to the collective, who's going to own that in the final analysis, right? If everybody comes up with a really interesting product and you're all contributing and you write some code together and you don't actually form the company, from a technical standpoint, each of you, when you say you write code, right, you each have the copyright in what you have written. And so what you're left with is a mess of jumbled IP rights. It's not clear. And while everybody is buddy-buddy today, and it might be fine, even if nobody ever raises a claim in the future, right, if somebody starts a company based on that IP, and that company goes on to try to get financing or do an exit, right, the acquirer or the investor hires somebody like me to come in and diligence the company. And we'll interview you and say, hey, like, where did all this come from? Talk about the early founding, talk about what you guys did. And if we recognize someone else might have an IP claim on the fundamental IP of the company, you better bet we're going to make you go out and fix it. And that can be very expensive and complicated to do if, like, you're about to IPO or about to go through an exit event. You got to track down the people that you had the jam sessions with in the very beginning and make sure you get an IP assignment from them. So all of which is to say, forming an entity is relatively straightforward. It's pretty cheap to do. It's pretty easy. And if you're really serious about starting a company, you ought to do it pretty early because it helps you avoid problems of, oh gosh, I wish I had just gotten those couple of pieces of paper signed then. Now it's been 6 months and I got to go track down this person and hope that they're going to be reasonable and sign a bunch of things so I can go take this idea and make it into something that's worthwhile. So, forming an entity, liability, making sure that you have kind of a clear place for your IP to land. There's a couple other things to think about, right? If you're picking which of the different types of entities you've got, right? Assuming that we're now all agreed we got to form something, you got to think about who your owners are going to be, what you think the taxation situation needs to be for the company, how are you going to get financing. Almost all of these, by the way, are going to drive you toward a C Corp, but I want to tick through them really quickly. C Corporation, where we're going, probably the most prevalent type of corporate form for anybody coming to HBS to do. You get liability protection. You can have any number of different owners from any number of jurisdictions. So unlike what we'll talk about, an S corp, there's no limit on having non-U.S. persons. You can have multiple classes of stock. It's sort of the most flexible of all kinds of entities and the most well understood by investors. The one quirk, or the one thing you need to look out for, is unlike a limited liability company, which is a pass-through entity for tax purposes, C corps are subject to what we call double taxation, meaning your C corporation is a legal person. It's like its own little mini NIC, right? NIC's going to go form NIC Incorporated, NIC Mains Incorporated, and it's going to get a bunch of money from its customers. That money, when it comes in, the corporation pays tax. And if the corporation wants to make a distribution to NIC, saying, congratulations for being an owner of a successful business, we earned a bunch of money this year, here is your dividend, that's also taxed, right? Double taxation. Versus if it were an LLC, right, the money that comes into the LLC is just imputed to NIC. So the IRS looks at it as if the LLC doesn't even exist, right? It just flows up to NIC. So if you were opening, a food truck, like a cash business, LLC is a great structure, right? You're not looking for a VC investment. You're probably a single person or maybe 2 or 3 people owning it. And it's going to be mostly a cash business where you're trying to get money into the business, reinvest some, but mostly take it out as dividends. However, most of you are going to be looking for outside sources of financing. So the double taxation hit that you take is not really something for you to worry about, because most of the time you're actually not dividending a lot of money out of your C corp. You're taking money into the business, you're probably operating at a loss, and to the extent you have money in the business, you're probably reinvesting it in the business to begin with, right? You're not doing distributions to owners just yet. Plus, most VCs don't invest in LLCs anyway, right, for a variety of their own reasons. So C corp is probably how it's going to be. Sometimes you hear about S corporations. All an S corp is a tax election that you can make to say, look, I'm going to have a corporation, but I'm going to subject it to a bunch of different restrictions so that it can be treated like an LLC for tax purposes. Almost 100% of the time for all of you, this doesn't make sense, right? Because the big thing with an S corp is you can't have 2 different classes of stock. And guess what? When venture capitalists or any other outside investor invest in your company, they're going to want preferred stock. They don't want common stock like founders have. They want a class of stock that is in preference to the common stock, meaning it's got better economic rights, it's got control rights, it has a couple of things about it that make it more valuable, special, different, above you, right? If any of you are multi-time founders, you've probably experienced what it's like to negotiate some of that stuff, but it's absolutely typical and absolutely the expectation. So every single S corp that's ever come to me has, the founders have pretty quickly dropped that election and just gone to a regular C corp because they realize, okay, look, I got to get funded, and people don't typically fund S corps. We talked a bit about LLCs. One thing I will also say about an LLC, and we'll get to this when we talk about governance, the beauty of the Delaware C corp is that Delaware, 100 years ago, decided, for whatever reason, even though they have beaches and they've got the Amtrak that runs through, they decided they wanted to define themselves as the place for corporations to be in America. So they developed a body of corporate law, and they developed a separate court system that's specifically focused on corporate law in Delaware. So it's a separate court called the Court of Chancery to make themselves the best possible jurisdiction in which corporations can incorporate and do business, to make things kind of fast, easy, predictable. And they've succeeded. So they are now the gold standard, and that's partly because there's a whole bunch of nice, clear statutory law and a bunch of judicial decisions that have come out over time that produce kind of the background common law, we call it, of how you interpret statute, that gets everybody around the table, investors, founders alike, comfortable that there's predictability. When you form a Delaware C corp, there's a really well-trod path of exactly how all of us understand what a board of directors is supposed to be considering when they make a decision. What rights stockholders have when other stockholders vote about something that maybe you, as a minority stockholder, were not so excited about, and you want to protest it, right? You want to get appraisal rights in the sale of the company. So versus picking a random jurisdiction somewhere else out there, right, where the law is not quite as settled, they don't have as many corporations. If you have to go into court, there isn't a speed-tracked separate court system that helps make things happen more quickly for you. There's good reasons why people avoid that, and they just stick with Delaware. C corp versus LLC, though, even in Delaware, and this is an important point on LLCs, if you're a C corp, the actual documentation you have to put together, that you have to negotiate with the co-founders and the people who have an economic right in the business, it's pretty minimal because all of that statutory law and all of that common law takes care of many of the basics. There's kind of an undergirding set of rules that all C corps play by, right? That you can contract around and modify, but it's just there for you and it's available. LLCs are different. The Delaware LLC statute, like most LLC statutes, is pretty bare bones. LLCs are typically governed by a very complex 50, 60-page document called an operating agreement that is kind of a mashup of the kinds of concepts that Delaware law covers already for C corps, but it's privately negotiated. And so the complexity with an LLC is that all of that has to be kind of put together at the time of founding and negotiated and then thought through, and it can be kind of expensive from a legal standpoint, right? To hire a lawyer to help you do all of that and figure out all the nuances of how the waterfall works on an exit, what rights you have as a holder of membership interest in the LLC, how management works, how taxation is going to work, all of that stuff. So it's another reason why people tend not to pick LLCs is because just the raw cost of starting it up, if you're going to have multiple founders and you're all focused on making it a long-term thing, can be higher than a C corp because you can't really do it in a cookie-cutter way because you just have to negotiate everything. All right, so that's a bit on types of entities. We already talked about where you should form it. I'm not going to pull you guys, it's Delaware. Every once in a while, someone's like, oh, I've got a crypto startup, or I want to do NFTs. I've heard Wisconsin's great because they have, or Wyoming is great because they have anonymity. Like, maybe there are some other jurisdictions where there's a quirk about your company, where there's some reason why you want to form there. But I would press on that a little bit, and I would query it and think about who your investors are going to be and whether they're going to want to deal with having a Nevada LLC because you think it's a good idea. Versus, if you're like, oh, I have to have a certain state entity to go after certain state funding. Sometimes we see clients do that, but they do it as a subsidiary. They make the C corp be the head corporation, right? And then when they decide they want to go for some big grant out of the state of Utah, they make a Utah LLC or a Utah corporation to be the one to go after the grant, and it's just a wholly owned sub of the parent. But I don't want to get too far down the rabbit hole on all that. It's kind of outside the scope of today's presentation. All right, I'm going to pause there for a second because I've been talking at you for a hot minute, and I'm going to wait for somebody to ask a question because I'm sure somebody's got one, and I want to make sure that we have a chance to open floor and sort of break the ice a little bit so you guys feel comfortable talking. So anybody who's caffeinated enough want to throw something out there, I'm all ears. You can just unmute. You don't have to raise hands or anything. Yes, Aditya, you were first, and then Vishal.
How does it work if you're operating across different countries? We've incorporated in Delaware, but most of our operations are going to be in India. So should we incorporate in both places, or if you could just talk to that, that would be helpful.
That is a great question. So I think I'm going to give you an awful lawyer's answer. It depends. So if you actually are going to have a bunch of people in a different jurisdiction, it's worthwhile to do a little bit of research about what the requirements are to employ people and to operate in that other jurisdiction. I have a lot of startups that I work with that have operations all across the globe, and it can be expensive to maintain multiple subsidiaries in multiple markets, right? You have the startup costs, you have ongoing legal costs, you have filing, there's sort of an operational burden of running it all. But there are companies that will help you do that on an outsourced basis, right? So I have a ton of companies who use deal or globalization partners or other so-called PEOs, right? To be effectively your representative in that market, because they will be the ones that deal with local employment law and making sure the payroll's done properly and knowing how you accrue vacation and the kind of things that you need to be thinking about when you employ people in other jurisdictions. Well, actually, let me zoom out for a second and lay something on you guys about employment law. And I know that's not really the subject of the discussion, but I think it's important for everyone to understand kind of as a kind of baseline setting. In the US and in most other jurisdictions, even if you can contract around certain things that are kind of baseline true, right? It's America. Two businesses can contract for almost anything. Employment law is one of those places where statute will trump whatever you try to agree to in contract, which makes sense, right? Because if you were allowed to just contract with employees, and ignore whatever the baseline rules were, it would be a recipe for abuse, right? Because you would just, it would be kind of part of the market dynamic of if you had very high unemployment rates, you could have all kinds of really usurious, terrible terms that get visited upon employees. So that makes it very important when you're employing somebody in a different jurisdiction to really know local law. And that means you need somebody like Deal or some other PEO, or you'd want to have your own local entity with your own local lawyer, right? So to your point, Aditya, if you've got real operations in India and you're going to have like 20, 30 people working for you, at a certain point, it probably makes sense to establish your own subsidiary because Deal charges you a little bit of an upcharge on each person that you employ there. And that can be worth it if you have a distributed workforce in a bunch of different countries. But if you've got 20 people in one spot, you probably want to have a local lawyer and a local entity to employ them, because then you're not paying that extra little bit of margin on every single person that they're administering for you. And you're going to have to become familiar with local law requirements on how people are employed, how you let them go, how you deal with leaves, things like that. And also tax is another thing too. If you have a bunch of revenue running into, if you have clients in India, maybe you're serving out of India, you need to make sure that you have somebody who's working on the Indian side and on the US side who understands the interplay between the two jurisdictions and how, when you capitalize one with money from the other, how to do it in a way that doesn't subject you to kind of unknown tax implications. Does that make sense? Excellent, thank you. It's a very good question.
Thank you.
Vishal, your question.
Yep, thank you. I was wondering if you're aware of any international jurisdictions that offer, that are pretty attractive for VC investors, but may offer better tax terms. I was wondering if there's any common ones that come to your mind outside of the US for incorporations, for C Corp, or something similar.
Well, I think there's a couple of, it's a tough question to answer without really understanding what your business plans to do. And I will also, it's important to name the boundaries of one's experience. I'm not a tax attorney, so I know there's probably some great tricks. I know I've done some IP organizations through Ireland, right? Because they've got some interesting tricks you can do about offshoring IP so that when you get royalties on it, it's sort of different. From that's more, once your company is pretty developed and it's worthwhile to spend the money and the time to do that, it can be worth it, right? That was the thing I did for sort of a big silicon kind of chip manufacturer, so that makes sense. I think most investors that I see in an early stage startup, they're familiar with, particularly US VCs, they're very familiar with Delaware law. And so they would want a US topco that is a Delaware-based C corporation. That topco might have subsidiaries, right? And the subsidiaries might have their own assets, but in terms of trying to invest in an entity that is not a US entity because it's better for tax reasons, I just can't tell you if there's a particular strategy that's better. I'm definitely aware that people use the Caymans, right? And I know there's some complexity to that. Use the Caymans for certain types of investments, but that's beyond the boundaries of what I normally see for most startups. It's it costs a lot more in the way of time and legal spend and energy to maintain a 4-entity stack in a couple of different jurisdictions to take advantage of some tax loophole than most startups are ready to put up for.
Thank you.
All right, anybody else have a question that they want to throw out? I'm happy to take any of them before we keep going.
Yeah, I was curious,
Yes.
what stage should you be at before you think about forming an entity?
So I would say, this is sort of getting back to the original slide here about, the mixing and matching of IP rights, among a bunch of people. I would say once you feel like you're really going to give it a go, right? If anybody who's around the table thinks, okay, I'm taking this pretty seriously, this is no longer a class project, I think I might actually want to start a business, that's probably the time when you should start thinking about forming an entity. Because it's not that expensive to do, right? If you've talked to other folks who have formed an entity or if you've done yourself, either you can use a platform like a Clerky or a Stripe Atlas, they're perfectly fine at forming an entity, or you can work with a law firm. And most law firms, ours included, when you have an attractive startup that comes out of HBS, you're going to defer your legal fees. So you're not paying out of pocket for anything. You only pay the law firm back if you're successful in funding. So taking a bit of a bet on you. So there's sort of and the platforms you can use are not that expensive. So there's really not much downside and not much cost to forming an entity in the beginning if you can do it in an efficient way. So I'd say, whatever bogey you're placing out in the future about, we'll form an entity then, consider backing it up a little bit in time and doing it a little bit earlier. That's my bias, right? Because across a large enough end of clients over many years, you see enough situations where, even though it's rare, a couple of people got together, they thought about an idea, they didn't form a company, and then somebody's going to take an offshoot of that idea and go form it themselves, but there was a disagreement beforehand, and so it's just not clear where the rights are. And you always think, gosh, if I could put all of you in a time machine and put you back to when you're all around the table in front of the whiteboard at the iLab and say, go form an entity tonight and then sign all your agreements, then it's really clear. Then you can use vesting and equity and all these other tools to try to figure out where everyone's rights are if somebody leaves the business. I see here. I just got $500 from Clerky, super quick, less than 1 week to process. That sounds right? It's not that expensive. And obviously you got to pay in Delaware too, right? You got to pay them a couple $100 to form. One thing I will say though about using one of those platforms, they're pretty good for folks who are at HBS, who have the kind of, who are like you, you guys and who have that sort of acumen and who are going to do it carefully, they make it fairly foolproof, but it's not entirely foolproof. Every once in a while, we'll get a new client who comes to us who incorporated on Clerky, and they did something because they didn't really understand how the checklist works, and they issued all of themselves stock options out of the equity plan instead of restricted stock. And you go, okay, gosh, we got to go kind of re-engineer this and try to do what we can to reverse it. So, you can mess things up doing it without guidance, but it's not that hard to get right, and it's pretty straightforward. You can just ask friends. And frankly, you can come to office hours with any of the LIRs, and we can just walk you through it and kind of give you pointers about the kinds of things you expect to do. So you should, I think using Clerky is perfectly acceptable. Okay, cool. Other questions before we start talking about capitalization? Yes, Grace. Oh, and then Tunir.
Well, on that related note to Sue's question, so you've never if we're running some kind of alpha test, alpha program, there's no instances you've seen where the startup hasn't been incorporated yet?
Oh, no, I see people zip past the point where they probably should have incorporated all the time, right? This is sort of about what one would do in the ideal case. The real world's super messy. We get people who come in all the time and say, well, I've actually got my first term sheet and I don't have a company yet. That's a mind blower, right? Because there's some fair market value considerations that come along with that can be a little complex to try to kind of engineer around. So no, look, don't get me wrong. We see people who are far down the path beyond where I would wish they had formed an entity all the time. And usually, one of the nice things about corporate law is you can be pretty creative, right? You can find solutions and get somebody to, if they've arrived at a certain point, you can usually chart a path from where they are to where they need to be that's practical and low cost. Some of the places where it can be more difficult to do that, and yes, Ashka, I'll get to your question just here. Let me actually write that in the parking lot so I don't forget. Change an entity. There are some scenarios where it is harder to do that, right? One of them is where a lot of time has passed, and the other one is where people have mixed IP and then they've decided they don't want to work together anymore. So kind of stitching those two things back together can be difficult, right? Because I know I'm going to jump ahead a little bit, but I want to kind of start with some 101 about how people think about value when they get shares in a company. So if you form a company, it's an empty bucket, right? It's a corporate entity. It's a person at law that has nothing in it, no value. So that's why you get your shares in the beginning at a millionth of a penny, par value, right? Something you can pay $10 and get 1 million shares, whatever. That's good because whenever you get something, if you're getting something that is worth more than what you're paying for it, you owe tax. You don't want to owe tax. So in your example, Grace, right? If you form an entity or you don't form an entity, right? You're sort of chugging along and you're building value in a company, and let's say you get your very first series of customer contracts and you get a term sheet from your VC that says, wow, you guys are doing great, we love your product, we think your company might be worth X, we want to put money in. And you think, oh gosh, either we formed and never issued everyone their equity, or we have to go form the company now. You have a bit of a sticky situation, a bit of a question about, when I form this entity, is it actually valueless right now? Can I issue shares of stock to everybody for 1 millionth of a penny anymore? Or am I forming an entity that the moment I dump all of my IP into the entity already has some value because we're already kind of well down the path? You can probably find a way to get comfortable that the value is totally amorphous, right? Because it's still just a wing and a prayer. And most of the time you don't get to a true, a priced round term sheet without having an entity. That's a fact pattern I've actually never seen, thankfully. But it does make things a little bit more difficult for you than if you had just formed it when it was really an empty bucket of nothing. But to your example, I think probably the stickier thing to get around would be if you guys do this alpha test and you've started developing a product and everything, and then one or two of the co-founders decides to leave the business, particularly if it's not on good terms, the ones who remain, is it clear that they actually own the product that they're going to be building around? Or are there aspects of it that these other people might claim sometime in the future, or their heirs or successors might claim sometime in the future once you have $1 billion company? Oh, hey, by the way, you remember that time that we all did those jam sessions and we developed the early product? I think I have some right to get paid either in equity or in royalty for what you're producing today. It's there's a bunch of examples of it, right? You guys have probably read in HBS cases about, Facebook and other platforms like the Zipcar handshake deal where these early things can have a major effect even though everybody's just, at a baseball game talking, right? So you had one, and I think Tunir, you had another one. Yes, Tunir. Oh, sorry, I think you might be muted. Try again. I can't hear you, I'm sorry. If you could type it in the chat, I'll happily answer it. You can type in the chat. And while you're putting that in keyboard, I want to answer, somebody asked a question about changes in entity form over time. The short answer is yes, and then I'll give you another awful lawyer answer. It depends. You can change the form of your entity over time. The longer you've been operating the entity, the more assets and value the entity has, the more thoughtful you have to be about whether there is a tax impact when you change the form of entity from an LLC to a C Corp. There's some complexities around how how that can affect what's called qualified small business stock status and the shares you have in the company. There's also sort of some timing questions around when in the tax year it happens. That's all way beyond the scope of what we're talking about today, but the short answer is yes, you can change form over time. It's just, if you're thinking about shifting form later, you should think about whether or not you should just start with that form today. Because you can bump into some tax implications and have to do a bunch of jujitsu that you could just have avoided if you're just going to change the form of entity in the future. Question from Tanir, can you do an 83B election on a platform like Clerky? I believe you can. I'm going to write that down because 83Bs are super important. And keep me honest, everybody, we're going to talk about 83Bs when we get to restricted stock agreements. But that is one where I know that they covered it in the other session, but because 46% of you, to be precise, didn't get to go to the other session, that is one of these things where, Grace Howe is saying most of the time, you can do some, you can twist yourself into a pretzel and do things in corporate law that help kind of get you to the right result. 83B is one of those rare areas where it is very, very, very difficult, if not impossible, to fix if it has been missed, because the IRS is just, the IRS is the IRS. So it can be fixed, depends on the circumstances, but it's so avoidable and so important that we will spend a good minute, and I'll give you like a 30-second fear of God speech about the 83B, because it's very important. Okay, I'm going to keep us moving for the sake of time, but if you guys have other questions around entity or entity formation, write them down. I want to hit them in the parking lot before we're done. Sound good? Okay. All right, we talked about type of entities. Let's talk about capitalization. So typically, when we start a company, you'll probably see the same thing on Clerky and other platforms. You typically authorize a whole mess of shares that can possibly be issued before having to go back and do an amendment to your charter to make more shares authorized. That bucket is usually 10 million shares. The reason we pick 10 million and most platforms pick 10 million is Delaware, surprising no one, charges you every year for the pleasure of existing as a corporation in the state of Delaware. And what they charge you is called franchise tax, quote unquote, and it's a function and part of the number of shares you have outstanding and the value of your company. And so over time, firms have figured out that it is there's like a Pareto optimal point of having enough granularity, meaning you have enough individual shares you can grant them when you give someone 1% of the company, it feels good. You're not giving them one share, you're giving them 50,000 shares or whatever it is. The intersection of that concept and how much you have to pay Delaware. If you did 100 million shares, you'd be paying them a couple grand a year. That doesn't make any sense. But if you do 10 million shares as a startup, you pay them like $300-400 a year, and that's fine. That's like sort of gives you enough space. We also typically issue somewhere around 4 million shares to the founders to split. So if you're doing a business with 3 people and you're going a third, we'll issue you 4 million shares and you'll each take about a third of that, give or take. And then we put some shares aside. We reserve them for issuance under something called your equity incentive plan. That's shares that kind of sit in a bucket that you can issue options against later to employees that you hire. Now, I don't want to ask for a show of hands, I'll just assume there's going to be somebody in the room who does not understand the difference between a stock option and getting shares. So very quickly, a stock option is just a contract that says, I, Gabe, as employee of this company, can purchase shares of the company in the future once my option is vested at a per share price that's equal to today's fair market value. So I'm getting an option today, the shares are worth 5 cents. I can wait, and as I'm employed, maybe the value goes up, but I can still exercise it for 5 cents a share. I only do it, it only makes sense if the options are in the black, right? The company's worth $1 a share now, so I'll exercise my 5-cent option, and I've got 95 cents of gain. That's an option. Very important point about options. You are not an equity holder under Delaware law if you've got options, right? You just have a contract that lets you become an equity holder in the future. So when it comes time to do things like vote shares that are actually held by people to make a company decision that goes to the stockholders, like electing the people who go and serve on the board of directors, someone who merely holds an option is not consulted. He or she does not have a right to vote when it comes to stockholder matters because he or she is not a stockholder. If they exercise their option and they pay money to the company to the tune of whatever their fair market value is, times whatever number of shares they're exercising for, and then they get shares, then once they have shares, obviously now they're a shareholder. They've got rights at Delaware law. So that's one of the reasons why in the early days when you're giving equity out to founders, it's really important for a founder to actually get restricted stock in the company, real shares, actual securities in the company that entitle you to your rights at Delaware law to vote versus having an option. Now, the benefit of an option, obviously, is you don't have to put any cash into the company to get it, right? And so options are very important for employees because most of the time you're giving an option once the company already has some value, right? You're buying your shares as founders at a millionth of a penny, so you can put in $10 and get 1 million shares. But once your shares are worth 10 cents, if you want a meaningful percentage of the company, you got to put up a couple of grand, maybe more, right? And so most of those employees, when they're starting, don't want to put that kind of cash into the company. They'd rather have an option so they can just hang on to it and only exercise it or be netted out in an exit event if it makes sense, right? So that's options and why you have an option plan versus restricted stock that goes to the founders. Okay, so you've got your restricted stock split by the founders, you've got your option pool, and then you have all these other shares that are out there that are available for issuance under the charter. Those don't matter for your purposes in terms of figuring out what your fully diluted percentage of the company is, what your outstanding. Yes, so Hyundai, yes, I will. Oh, and hi, Hyundai. I will talk about vesting schedule and tax implications. We have a whole slide on that, don't worry. And that's where the 83B comes in. So that extra bolus of shares that's available for issuance under your charter does not matter when it comes to figuring out your ownership interest in the company. The only reason why platforms like Clerky or law firms give you a bunch of extra buffer spaces because we know things change in the beginning. You might start a company with 2 people and realize, oh gosh, we got to bring on a more technical co-founder in this area. And it just saves you one extra step. You don't have to go back to Delaware and file a new charter and pay them a filing fee and pay your law firm to draft a board consent and all of that stuff if you just already have a bunch of space available under your charter to issue more equity to somebody, right? That's the reason why it's there. And then once you do your first, what we call priced round, meaning where a venture capital firm puts money into your company. In exchange, they get preferred stock. The way that they get their preferred stock is you guys all draft a new charter. And you file it in Delaware anyway. And that's when everybody right-sizes the number of shares of common stock to fit with whatever the terms of the round are. And I know you guys have a future session with one of my colleagues in the LIR group about terms of venture capital financings. And I'm sure you guys will talk about preferred stock and all the joys it comes with at that point. But that's where I'll leave it. So suffice to say, you're going to have extra space under your charter to issue shares, and that's something the board would do if you do decide to issue more shares, and that's typical and normal. Okay, let's talk through an example of capitalization and how it works. I've got our friends Spinco Therapeutics up on the board over here. So we've formed them. You've got 10 million authorized shares. There's 5 million allocated to all the founders together and the pool, right? So they're splitting it out. So I want to call your attention to 2 ways that people typically talk about ownership of a company: the issued and outstanding percentage and the fully diluted percentage. So issued and outstanding percentage, as you notice, this ignores the option pool, which makes sense because the option pool doesn't represent shares that are actually in anyone's hands. If the company were sold today, it would be, the proceeds would be split per the charter according to everyone's owned interest in the company, people who are actually shareholders at the time, right? And if you had to take a vote, for example, it would look only at the people who are holding shares of the company at the time, not at option holders. And right now, we're looking at the founding of the company, and there's an option pool. You haven't even issued any options yet, so no one could even exercise and become a shareholder. So it's 0 for our purposes. That's your issued and outstanding share number. Now, very importantly, and this is why the distinction's key, if you were to look, you zip forward and you were to look at like the fully diluted percentage, you would think that if Civetta and Eric and Rebecca voted together, they would not be able to make the 50% threshold needed to take a stockholder action. We'll talk about why that's important in a moment. But if you thought that, you'd be wrong, because you would be looking at the percentage in the column marked fully diluted percentage. That speaks to economic rights in the company that presupposes that the entirety of the option pool actually ends up getting issued to optionees in the future. It's a way of saying, okay, like, I think I'm going to have at least a certain number of employees. It'll probably take X percentage of the company over time. So where I am on a fully diluted percentage, meaning assuming that all of those shares get issued and exercised by all the employees that I will in the future hire, what portion of the company do I have with the shares I've got today, right? But none of that is relevant for purposes of taking a vote right now. If the stockholders want to meet and decide who's going to be on the board of directors, you have to, unless you do something different in your charter, right? By Delaware law, you have to crack the 50% threshold. You have to have a majority. So here, the way these guys have split up the company, you can actually get there with any set of the 3 founders, right? It's like a 3 versus 2 rule. Not that you anticipate people having contentious stockholder votes in the beginning, right, where it matters who's got what, but it can be important to think about things at the level of rights, right, to understand what everyone's kind of, if everyone just flexes the muscle they have under the documents, what the result would be versus where we all want to be, right, which is up here at the level of interests, talking with each other about what makes sense, what helps the company, what helps the business, right? But understanding rights is very important. So the distinction between fully diluted percentage and issued and outstanding percentage is essential. And one place where it comes up very often with startups is when you talk to people who you're going to hire, like an early engineering hire, and you say to that person, oh, like, I think I'm going to hire you for X percent of the company. What do you mean specifically? Do you mean X percent of the fully diluted or X percent of the issued and outstanding ownership? Because those are 2 different numbers, and it can be meaningful to people. And so you need to think, I mean, in general, like, when you talk to your lawyers, they will all harangue you not to promise people particular percentages of the company because there's complications with that and you can kind of talk past each other. But we all understand you're going to talk about it that way, and that's how people want to think about their equity ownership interest. You always do want to reduce it to a number in the final documents you give them, but just to make sure you're not talking past each other, you should always use the fully diluted capitalization number when you're thinking about and talking about percentages, in part because it helps you avoid having to do the circular math that you would constantly have to do of saying, well, if I want to give you X percent, that sort of dilutes the rest of us directly on an issued and outstanding basis. So if I always calculate an issued and outstanding, I'm going to get to kind of funny numbers, and it's not going to kind of reference my option pool in the way that I expect my option pool to be factored in. So fully diluted is typically the way people talk about that, and this is a place where it commonly comes up. Whew, I'm going to pause there for a second. I'm imagining somebody probably has a question based on what we just ripped through in 5 minutes, because it's going to be a fairly complex topic. So open floor. What questions have you all got about what we just talked about?
So for your example on voting.
Yes, Chris, and then Conrad next. I saw your hand. Yes, Chris. No, please, jump in.
For your example on voting, even if options had been issued because that person does not own equity, they don't have a vote.
Correct.
So you would still not include that in the denominator, even if the entire option pool has been issued?
Correct. Now, okay. The thing, now this gets in a bit of parliamentary procedure, right? Because let's imagine you have a bunch of options issued and they're vested, meaning people have the right to exercise them. So if you're running up toward a stockholder vote and the people who hold options are aware of the impending stockholder vote and they want to vote, right? If they exercise before what we call the record date, meaning the date on which we say, look, we take a snapshot of who the stockholders are as of this date for purposes of knowing who needs to vote on something, in theory, right, your denominator can change. So you have to be thoughtful about the fact that you can't control, you can't tell people, you can't exercise your option today because I want to do my voting calculations, right? They could just decide to, they have the right to put money in, the company's got to process it and then give them their shares. So there's a bunch, and you're going to see when you form a company, there are 2 big documents, which we'll talk through a little bit, that govern everyone's kind of rights and responsibilities to one another. One is called the charter, that's publicly filed in Delaware, that deals with the number of shares you've got, the different classes of equity. It's very simple in the beginning, becomes more complex once you take on venture capital, right? And then there's something called the bylaws, which is all the boring stuff that'll send you to sleep unless and until you have a contentious fight from a corporate governance standpoint. And that's what determines when the record date is set, how you can call meetings of stockholders, how the stockholders can act or not act by written consent, how the board has to call meetings, how much notice people get for a board meeting, because some of this stuff can really matter, to your point, Chris, particularly if you're coming up on something that's contested or that might be contested, like an exit event of the company. You got to think, like if I have razor-thin margins on the vote that I need, and I know I have a bunch of optionees who are going to be ticked about this company deal, right? And I need an all-common stock vote to pass it. Like, is that going to change my analysis if they put in a bunch of exercises right before the starting gun, right, for when we start counting votes? So you can end up in a pretty complex situation. So I'm glad you asked the question. I think, Conrad, you were next with a question.
Yes. Could you talk about positives and negatives of, like, and this is more like fundraising, the capitalization of shares, of like doing a new round versus opening up a prior round to get more equity?
Oh, yes. There's almost like a question behind the question, in the sense that well, let me set out a couple of assumptions first, right? So I'm assuming when you're talking about opening up a prior round or doing a new round, you're talking about a priced round where you're issuing preferred stock, right? Versus like a SAFE or something else, which is, or SAFEs being simple agreement for future equity, or like a convertible note or some other structure, right?
Yes. And specifically, we've done a friends and family round, so we already have all that stuff priced and did it. We need to do something again. So the question is what are the pros and cons of doing a brand new round and pricing it separately versus trying to open up the first round again and managing that with the existing investor base?
I mean, my view on this is, if you open up the prior round, it sounds like almost by definition it's at a flat valuation, right? You're going to be selling securities at the same price you sold them at before, of the same class as what people bought 6 months ago, which implies that your valuation is flat. To me, I'd much rather have a new round where you, at least, even if it's a small bump, there's a bump up in valuation, right? So people pay marginally more for the same percentage of your company than the other folks did before, right? The downside to that, quote unquote, is it is a new round of financing documents. There's a little more legal complexity. You're layering on a second type of security on top of the first. You might have seed 1, right? And now you're going to sell seed 2. Seed 1 was $1, seed 2 is $1.10. Now your charter and all your investment documents have 2 sleeves of stock running through it. You've got 3. You've got your common stock at the bottom, seed 1 and seed 2. And it opens up questions like, well, do the seed 2 get their own board representative? Do they have separate and different rights? When you have seed 1 and seed 2, do they count together for certain votes, or do you have individual block provisions for both classes of preferred equity? So you avoid all those questions if you just do a flat round at your prior valuation. But if you're taking on a bunch of new cash, if it's enough of it, like, it's more dilutive to you. And you and your present investors may not be excited about that. You may want to have something where you show a bit of an uptick in value. Another option for you that you haven't really asked about is, oftentimes I will see companies, if they can't quite make it to the next round, like they got to put more gas in the tank, they'll do a bridge round, and they'll do it on something that's a convertible instrument. So you don't have to answer the valuation question right on, right? You don't have to actually establish a valuation. You do a SAFE where you can kind of put a bogey in the air about, okay, here's the post-money valuation of the SAFE and how much dollars am I willing to take against that, and I can kind of do the dilution calculation today and understand what it will mean when it converts, but I'm not actually going through the pain of doing a new round of financing documents and converting it today, because whatever, it's not worth it. It's only $1 million, whatever it is. Like, you typically don't want to do a whole new round of priced equity documents for less than like $4 or $5 million, just because the legal fees and negotiation and time are a pain. And as a percentage, like, they're just too high to justify most of the time.
Totally what we were thinking about. Appreciate it. Yeah, that's a
no worries.
great answer. I appreciate your
And I know there's a whole other session about that. And like this, like, we could talk about this topic for hours. It can be very complex and rich, but hopefully that's enough to point you in the right direction. Did I see a hand over here before? Was that Matt or Hannah or Casey or somebody? I couldn't tell. No? Nothing? Okay. Somebody's just stretching? Cool. All right, let's keep talking. So we talked about capitalization, issued outstanding, fully diluted, governance structure. So I'm going to pause for just a quick sip of water before we talk about governance. Government loves governance. Okay. So in Delaware, the way that it works is you've got a board of directors that makes all the material decisions for the company, right? The board decides when you issue equity, when you enter material contracts with suppliers or commercial partners, when you sell the company, if you do fundraising, all of that stuff. They approve all the options. So the board obviously is very important. And they also hire and fire the executive team, right? They decide who gets to be the president, CEO, whatever. In the beginning, most of the time, if you have a couple of founders, you're all on the board, right? Because it's only like you're the same 3 humans around the table who do all of the different things, right? You play CEO and receptionist. You do it all. This obviously starts to change over time. But even in the beginning, it's important to understand the distinction between the board and the stockholders, because this is a place where founders are always asking me this question. Can I be fired? What happens if the other 2 gang up on me and kick me out? Like, should we sign a voting agreement or a founders agreement among the 3 of us personally that guarantees that no one's going to fire the other person. For a variety of reasons, the answer is no. But I want to talk about kind of why that is and what the baseline rights are at Delaware law. So your board of directors and who they are is established by the stockholders. At any time under Delaware law, if the stockholders want to, they can meet and they can decide we want to appoint a new board, because ultimately the stockholders are the company. The board serves at their pleasure. Obviously, this is absent having some contract that burdens how the stockholders can vote their shares and all of that stuff. That's for later in your preferred equity rounds when you do a voting agreement. For now, base case, stockholders choose. So if you have a board of Gabe, Cecilia, and Diana, right? But Gabe has 51% of the company. If Gabe wakes up tomorrow and decides, I want the board to be Gabe, Gabe can make the board Gabe, right? Gabe signs a one-person action of stockholder, right, at Delaware law, and sends it to the other two of you and says, by my power in Delaware law, I've now declared the board is me, and that's it. And the funny thing about Delaware law is when you act with your board of directors hat on, you have something called fiduciary duties. Your duties are to the stockholders of the corporation. You have to do things in their best interest. So when the three, if Gabe is an individual board member and you two are still stockholders of the company, Gabe can't go out and issue himself a bunch more shares just because he feels good this morning. His egg sandwich was delicious and he just wants more shares of the company. That's not something Gabe can do. I mean, he can technically do it, right? But he's going to get sued like that, right? And you'll probably win because it's a violation of his fiduciary duty. It's an insider transaction with no justification for the business, right? But it is totally different in stockholder land. When you're voting as a stockholder, you can vote and do whatever it is you want to do with your shareholdings in the company in your raw capitalist interest, because this is America and that's how it works. You don't need to consider anyone else, right? It is something you can do because you woke up on the wrong side of the bed this morning, or you decided you wanted to block an action because you felt like it, right? You're a stockholder. You have duties only to yourself. There's no imputed duty at law for you to act in a particular way. And so you'll see in this, I know it's pulling a bit from the later venture financing round workshop you guys are going to do. There's a big distinction between giving an investor the right to block something or have to approve something via their director seat, meaning the following actions need preferred director approval, versus saying you need to get a preferred stockholder vote to do these actions, right? When the preferred stockholders vote, they have no fiduciary duty. They can just decide yes or no because they feel like it, whereas the director actually has to think about what's in the best interest of the company. So how does this all apply to you guys as founders? So while it is true that Gabe could, from a technical standpoint under Delaware law, do what I just said he would do, right? Boot Cecilia, boot Diana, decide he's the only person on the board. It's important to remember, there's a difference between can and should, and this being America, even if you don't have a good fiduciary theory, right, Cecilia and Diana, to sue Gabe, you probably could still try, and the lawsuit itself or the threat of it would still tank the company, right? So that's one of the things I always remind founders. They're like, what if the two people who have more than a majority are gonna, no, they're probably not gonna gang up and fire you in a totally unfair way, because they're probably gonna tank their company if they do that, right? You probably have a friend or somebody who's a lawyer who can write you a demand letter and scare them enough, and they know that that's possible, that people generally don't exhibit capricious or bad behavior in the beginning for really no reason. That said, it is very important, as much as it's hard and it pains all of us, and it's a very lawyer way to think about it. Everybody's psyched in the beginning, but you have to plan for and build your company so that it can withstand a schism in the founding group, right? You should never, ever, ever go 50-50 for this reason. I'm dealing with a company right now that went 50-50, and they are literally stuck. The two founders now hate each other. It's horrible. I'm sorry, I don't mean to pour water on everybody because you guys are here because you're excited about the dream, but this does happen in 1 out of 100 companies. They're 50-50, and there literally is no way forward. They have to agree, or else the company, which owns, remember, it owns all the IP, it holds all the contracts between everybody, the company literally cannot do anything. They're locked, they're stuck. So you have to allow for a situation where 2 of the 3 people decide they're going to move forward with the business, and one of the people is cut out, right? You're not investable otherwise, right? Because someone could put money into you and oh gosh, I guess my safe is now worth nothing because these 2 people from HBS can't figure out their differences. Now the company's going nowhere and everyone's quit and gone taking consulting jobs or something. So it's very important to think about and that's part of why this company was structured the way that it was, right? You want to have enough people hopefully around the table where it's not just one person dominating, but sometimes in any founding pair, one person's gonna have the extra vote, at least until you take on more shareholders, whether it's preferred folks or folks who've got an option. And I've seen people solve that in a variety of ways too, right? Sometimes you take on a friend who's the third person and give them one share, and they're the tie break, right? If you really have worries about it. That's rare, but it does happen. But anyway, the big point here is don't think about the board as being fixed, like, oh, I'm on the board, therefore I can never be removed. The stockholders decide who's going to be on the board, right? So they are where the power ultimately rests. And as you'll see, once you get funded, you have your Delaware law rights and responsibilities and your abilities to vote, but you can also burden those by contract. You can have a voting agreement that says, I promise I will only vote my shares to elect Gabe as the common director, and I will only vote my shares to elect Teng and Kenny as the two investor directors, because you all just put $10 million in the company and we're going to give you control of the board. Not that you should do that in your first round. You shouldn't. It's a bad idea. But let's say you did. That's what your voting agreement would say. Okay? I saw a hand really quick. Is that Ali? Yes?
Just a quick question here.
Yeah.
So from an economic standpoint, like what if we both own each company we exactly own the same amount, so 50-50, but how can we structure it in a way where I guess decision making, like one of the co-founders has a slightly I don't know, just like their decision just makes just kind of breaks the tie, if that kind of makes sense.
The best way to do it, let's imagine you and Sue start a company, okay, and you want to have the tie break and she's okay with it. You get 2 million shares, you get 2 million and 1 shares, and she has 2 million shares. This way you have like almost bang on the exact same economics, but you're using the extra share to give you the Delaware law right to be the tie break. There are other more complicated ways to try to do it, but your time and resources are scarce in the beginning, and like it's not worth spending $10,000 of legal time to draft some custom agreement with like a different voting or like build double voting into your charter or something, because your investors are going to rip all that up anyway. Right, they're going to say, I don't want a charter with a bunch of double voting things and like double power for one director versus another. Like, get rid of all that, and you're going to end up throwing away the work. And you can achieve the same thing, which is giving you the extra share. That's what I would do. Yes, Kenny. Kenny, go ahead. Oh, you're muted. Okay, if you can't come off mute, you can always pop into the chat, and I can try to answer it when it comes through. Any other questions before we talk about vesting? Yes, Grace.
I just want to understand fully the cost. So if you incorporate, there's a one-time fee, sounds like around $500 to incorporate, and then there's ongoing fees every single year paid to Delaware, around like $300. I don't know what the test is until you stop incorporating. So if there is hopefully not for any of us, but if there's a chance that the startup no longer, after you incorporate, maybe after graduation, you're like, I don't know, then you're still paying it every year until what happens?
Well, you can wind down. Yeah, you can wind down the company, right? Like if you incorporate the company in Delaware, and you pay them whatever $500 to incorporate it, you pay Clerky $500 for their documents, and you're running along and you decide, you know what, I'm done, I'm gonna go do something else. You can wind it down in Delaware with a filing, so you don't have to pay every year. And frankly, don't tell them a lawyer told you this, but if you don't pay them, they're not going to come after you at your home, right? The company, all that happens is your corporate entity just loses good standing in Delaware, so you can't do further transactions. So if you forget to pay your yearly fee to them, and you go to file a new charter, they'll say, nope, no new charters for you. You have to pay me, a late fee plus the fees that you owed me for the last 2 years you haven't paid or whatever. And like that sometimes comes up in the context of a financing, right? A company, their controller has forgotten to file their yearly filing in Delaware. God help me, I don't know how, but sometimes it happens. And there's a scramble right before closing. Oh gosh, we got to get back in good standing, or else Delaware won't accept the new charter. And the new charter is always a precondition of closing. No VC is going to cut you a check or send you a wire for $9 million when they don't see a charter that says, yes, there's preferred stock that I'm about to get. So I hope that answers your question.
Wait, and then, okay, that does, thank you so much. But if you also keep going on the startup successfully, then because I'm just trying to think, comparing your example of the person who didn't incorporate until term sheet, which definitely sounds too late, versus let's say someone who incorporates really early, you're technically paying this fee every single year that you're incorporated.
Yep, every March you pay. It's like $400, give or take. Every March you pay Delaware. But like in theory, if you wanted to be really cheeky about it, you would just not pay for a given year. And then if you ever needed to get back in good standing, you could pay plus a nominal late fee. But to me, like if you're serious about doing a startup and you're trying to hyper engineer around $400, something's wrong. Like you got to be targeting a much bigger, like sort of a much more ambitious dream where like the marginal $400 to like make sure the thing works is not going to be concerning to you, because hopefully by that point you've taken on some seed capital or gotten a accelerator grant or done something where like you're moving the business. And not to say you're going to spend $400 on nothing, but like being good standing in Delaware is important. So it shouldn't like you shouldn't be in like slow mode for 3-4 years if you're really serious about starting a business. So it shouldn't really stack up, at least in my mind.
Yeah, I think we just keep in mind like the personal runway of our founders, and
Oh, for sure. Look, if you're bootstrapping, it's literally just your own money, and you don't have co-founders to split it with you, and there's no other capital that's coming in, whether it's a grant or something else that can pay for a filing fee. Look, people make their own calls too, right? Like if you think it's going to be a whole year before you can get there, I would try to raise a little bit of seed capital first, even if it's from friends and family. But like if it's not there, you can try to form the entity as cheaply as possible, and then forget about keeping it in good standing. You also remember it's only due once a year in March. So if you formed an entity tonight, say, you don't have to pay Delaware the $400 until the clock comes all the way around to March, and then even then, if you wanted to just not pay them and end up in not in good standing, you could wait, right? Like they're not going to chase you down. All they do is they put your company on ice. All right. Was there another hand? Yes, Kenny, and then I want to move on to vesting because that's super important for us to talk about before we run out of time here. Go ahead, Kenny.
Okay, can you hear me?
Yeah, I got you.
Okay, great. So I wanted to add on just a little bit to what Ali was asking. So I've heard like arguments for 50-50 versus 51-49. I've heard the argument of the 50-50 is fine, it doesn't matter because a lot of the decisions that you actually care about are made at the board level. So it's really more about which founder sits on the board. Are there any cases where that 51-49 split would actually be advantageous from like what you were talking about from like a Delaware standpoint? Well,
I mean, you're right. So let's take the example and be really specific about it. If you form a company, let's say you and Nathan form a company, and you guys go 50-50 on the stock, and at founding you agree you're both on the board, right? Neither one of you has enough votes on your own to boot the other person off the board. So you're right, the board decides, and like you can't change the structure unless you both agree. Same thing would be true if you and Nathan and you conscripted Dylan to be your third board member, right, as the tiebreak. Dylan's not a stockholder in the company, but you can appoint someone who's not a stockholder in the company on the board, that's fine, right? Now your board is effectively locked unless you both agree. So you could be 50-50. The big decisions at the company level have to go through the board, other than all capital stock votes that are required to do things like take on a financing by amending or restating your charter, or exit the business by selling the company. So you guys still have a veto right on one another. You can still block one another so that the company can't move forward if you don't agree. But on anything that is a board-only decision that does not involve a stockholder vote, you got Dylan as a tiebreak. Now it gets quirky in terms of parliamentary procedure in here too, where Nathan can call a board meeting and you might miss it, and then Nathan and Dylan can conduct business at the board meeting because they have a quorum, right? They've got 2/3 and they can act if they agree. So you got to think a little bit about that. In general, I don't recommend 50-50 and trying to solve it with this board thing, because if what you're really getting at is you want a tie break, you guys just have to figure out who it's going to be between the two of you. Investing is going to help you get your heads around that a little bit. If you go through a current sovereign entity, if you go through a co-founder breakup, stop working in an entity you've created, should you go through the hassle of formalized? I can't see the whole chat, so Grace, I'll have you ask your question, Grace Hua, in a moment. I saw one other. So Kenny, have I answered your question enough for now? Good.
Yeah, that's great. Thank you.
All right, I've got a couple other hands. Yes, let's do 2 more questions, then I'll talk about vesting. So I saw Cecilia, your hand, and I've got Chisholm, your hand, and I think that's it for hands for now. And then Grace, you had a separate question in the chat that we can try to get to. So let's start with you, Cecilia, and then Chisholm.
Awesome. Thank you so much. So I'm wondering if, say, one of your co-founders is going to switch from being an advisor role into like a part-time role. so that means perhaps their equity split would change by the time they become part-time. Do you have any recommendations around that? Like in the co-founder agreement, should we specify, oh, if you are just going to dedicate a little bit of advising role, it will be, say, like token size 0.5%, but as soon as you join, like a year or two later, as part-time or full-time, it can be XYZ. I also got advice from a lawyer that if they join later and in the meantime, if you did create value in the meantime, the form of equity that they get will be in the form of option, like you mentioned.
Yes, exactly. That's the key. So that's a good question with a complex answer. I want to get to that in the context of vesting. So we're going to deal with that in a minute when I talk about restricted stock agreements, but I think that's a really good example. Thank you, Cecilia. Chisholm, you had a question also?
Yeah, my question's on investing. What are the legal ramifications of doing business with an expired sort of like, so if you kind of like go and you file like via Clerky and like you're an entity, but you aren't paying, like, and then you might like sign like a contract with a design partner or whatever. Like what are the legal ramifications of that, given like you're not an actual entity?
That's a great question. There's probably in our business being startup lawyers, there's often a distinction between sort of like the technical answer and the practical one. My guess is the technical answer is going to be in your design partner contract. There's probably a representation that they ask you to make. So there's a section of a contract usually called reps and warranties where you say these things are true about my business, and it's the things on the basis of which they contract with you. One of those reps is usually I'm duly formed and good standing in my jurisdiction of a corporation, and I've got the full right to perform under the contract, right, with no contingencies. So you'd probably technically be in violation of that rep, meaning you're not actually in good standing in your jurisdiction. Now, the question is, like, practically speaking, do they check? Do they care? What's their remedy since you are? Like, from like an uber technical standpoint, could they in theory say, well, I want to have rescission, meaning renege the contract entirely because one of the reps wasn't true? I mean, I guess technically they could try to argue that, but like really who's going to litigate that point? It sort of doesn't matter from where they sit. And also, what are their damages? Like, what could they possibly sue you for? Why does it matter to them whether you're in good standing or not? So I don't want to say that there's no ramification for it.
I guess my concern is like
probably not one that really matters to you in practically speaking.
Yeah, I guess one of my concerns is like, yeah, maybe that might work if you're like working with a smaller company who doesn't need to like dot all their I's and like cross all their T's. But if you're like working with like a big like well-known company or whatever, then like, I don't know. I'm just trying to figure out like, yeah. Anyway.
Well, no, but I would like, look, if you're working with a big well-known company, right? I think this is one of these things about cost and time. Like, it's only going to cost you a couple $100 to stay in compliance in Delaware. And like, if you're working with a big company, they ought to be paying you enough money where you could at least cover that, hopefully. Because they might check, right? They might do a bunch of vendor due diligence where they're like, look, we're IBM, you're not going to consult with us unless you've done a background check and we've seen your company and you've shown me your charter in Delaware and whatever else, right? Here's your proof of insurance. It can be a real pain to go through like an enterprise sales process, but it can be very lucrative. You just have to, like, my guess is you're probably going to have to get in compliance, and if you need the marginal $400 from them, you could also ask them for like an upfront payment of some nominal amount to kind of get you through that period if you're really that cash strapped. But I would, if you're going to, particularly if they make it a requirement, I would, for sure. All right, let's talk about vesting, because that's like the sort of where the buck really stops in terms of how all the different founding rights work. All right, restricted stock agreements. Super, super, super important. This is a document, when you get it, you should read every single line of it, and if you feel like you don't understand what one of the things is doing, you need to talk to your attorney about it, talk to your co-founders about it, read some blogs, and make sure you really get it, because this is going to be the document that defines how you can keep the shares you have in the company if you exit the company, under what circumstances they might accelerate, what happens even if you never exit the company. It's got things like a lockup, right of first refusal in it, a bunch of kind of bells and whistles that affect your equity in the business. And because you're not really being paid major salary, like, this is what you're all spending 90-hour weeks trying to build value in. So it's super, I can't overstate how important it is. You really have to read it carefully and not just say, oh, the platform, it's their standard form, whatever. It is, and all the law firms have their own standard forms too, and they're generally reasonable and market, right? In the sense that we all see each other's because we diligence each other's companies. But that doesn't mean you shouldn't feel totally comfortable with what's in there. And things can change, right? So you can look at it and say, look, I don't really like how this is drafted. Can you explain why it is? And you can decide if you want to make, you push your lawyers or push your co-founders to do something different. All right, it's got a bunch of parts. The biggest part by far and away is vesting. I assume everybody has a baseline understanding of what vesting is, but I'm going to give it to you super quick. All vesting is the company's ability to force you to sell them the shares that you purchased in the company back to the company, or force you to forfeit them. There's kind of two ways of it working mechanically, but the net effect is the same when you exit the business for any reason. And that right usually lapses over time. So when you start, you get issued your equity. Remember we talked about Delaware stockholder rights and why it's important? It's also, by the way, very important from a tax standpoint. There's a lot of great benefits to having the shares up front. To your point, Cecilia, about giving them to a co-founder or somebody else who's in the business. If you get the shares up front for very low par value, you've started your holding period for purposes of things like qualified small business stock, which can shield up to 10 million bucks in gains, right? If you have a qualifying business over the course of 5 years. Long-term capital gains, all of that stuff. And it also gives you the voting rights. So very important to actually get the shares is very different than an option agreement. So you have the shares, but the way the company feels secure, and all of you around the table feel secure with one another, is there's usually two elements to it. There is a cliff, meaning if you don't stay for more than 1 year, the company can take it all back. And then if you stay for more than 1 year, you get a quarter of the total shares you were allocated vested, meaning the company can't take them from you if you leave. And then after that, every month, you get one more little slug, 1/36 of the remainder, all the way through 4 years. That's the usual bogey. 4 years with a 1-year cliff is typical. Now, everyone's situation is different. You might say, look, I'm forming the entity today, but I've been working on it since January. So even though I'm getting the shares today, I'm going to give myself 7 months of credit investing. My vesting commencement date is going to be January 1, because that's when I started working. And, Ivan, when he joined the company, he only started working, even though he was a co-founder, in June. So his vesting commencement date is going to be June. So I'm sort of farther ahead in my vesting curve than he is, right? That's sort of a way of accounting for everybody's relative time spent working on the business. But everyone's, you still try to get your shares as of formation, in part because you want to get them for a millionth of a penny. You don't want to form the company, go build a bunch of value and say, oh gosh, I forgot to buy my shares. What do I buy them for now? Avoid the question. Get them for nothing. That's the whole point of forming the company. But the reason vesting is super important, by the way, is because it deals with the question of what happens if somebody leaves, right? It isn't really reasonable or fair for someone to keep 40 points of equity in the cap table if they decide to take some great consulting job somewhere that makes a bunch of money and not contribute to the business. Or if they go from being a full-time right in there with you co-founder to like, hey, I inherited a bunch of money, I'm gonna go move to Belize and I'll do 10 hours a week. The fact that you have vesting in place allows you to force, you laugh, it does happen. The fact that you have vesting in place allows you as a founding group to force a conversation. Not that you want to have to flex muscle, but just to say, look, if push really comes to shove, the board can decide to terminate your engagement with the company. Vesting is what allows us to take back those points of equity, because the whole theory of the cap table is those points are there to incentivize people to work super hard to build value in the business. And if 40% of it is sitting with you when you're running your surf shop somewhere in Belize, it's not going to work. If you're doing 10 hours a week and you're some idea-only super helpful co-founder, maybe you have a couple of points, but 30 some odd of those have to come back to us because I have to go find somebody else to fill your role because I'm in here in the trench digging on my own. That's the whole idea. It avoids the free rider problem. Plus, you're absolutely not investable by a venture capital firm or anybody if you don't have founders who are subject to vesting, because they have the same question. What happens if I put a bunch of money in this business and you guys get bored? How am I going to use the cap table to pull on the next group of people to help them work, right? Or if one of you remains and 2 of you leave, gosh, no one wants to join a company where it's burdened by a bunch of free riders, right? That's the whole idea. Super important concept. Other things that are in there are going to be things like, one thing to look out for. Every once in a while you see a form, by the way, this is an aside, where not only can the company buy back your shares if you leave, the shares that are unvested, but the company reserves the right to buy back your shares at the then current fair market value, even if they're vested if you leave, kind of like a full buyout. That is a super company favorable, super founder unfavorable position that I would try to negotiate out of any form that you see. Because imagine, right? You spent 2 years building value in the business and the business happens to be at like a meh point, right? You leave for some exogenous reason and they can buy it back for like 5 cents a share because that's what you happen to be selling options for at the time. Totally unworkable, totally unfavorable to founders. You're here for the long-term equity value. So write that straight out. Don't just gloss over, oh, it says repurchase rights. Read very carefully. Make sure it's vested shares stay with you, unvested shares come back. Now, most of these agreements will also say if you're terminated for cause, capital C, they can take everything back, including your vested shares. That is like the ultimate club the company can hold when someone, say, commits fraud, right? Or violates their invention assignment agreement with the company by withholding IP or something. So you'll oftentimes actually see that in forms of restricted stock agreement. That's one that I see as more market, right? If someone's actually behaving that badly and like actively trying to harm the company, the theory is the rest of us around the table should not be letting you participate in success because you're a headwind now, right? Like you're a bump in the road. You're not trying to help us, you're trying to hurt us. Okay. Two other things you're going to see in there that I don't want to spend a lot of time on. There's usually a right of first refusal. That also sometimes shows up in the bylaws. That means if you somehow find some person out there who's willing to buy a bunch of illiquid shares in an untested startup that are burdened by a bunch of restrictions and take them off your hands for money you're willing to take in exchange for those shares, like you can probably hear in the way that I frame that, it's almost impossible to find that person and have a market for your common stock, but let's assume you do. The company wants to control this cap table and not have a bunch of strangers with all those Delaware statutory rights they get by being stockholders. So they have the right of first refusal. They'll say, look, if you go find someone willing to pay you $30 for your shares, we get to swoop in and buy them instead, right? That's the way of the company keeping consolidated, and that's appropriate, right? You don't want to have random people on your cap table if you can avoid it. And finally, for the 1 out of 100 of you that's going to go public with your company, you have a lockup, which just says, look, if you go public, you can't sell your shares for 180 days. That's what keeps the value of the shares up so that the underwriters can make their money and people don't see founders dumping shares right after you go public, because that's not a great look for obvious reasons. Okay, vesting schedule. We talked a little bit about this and about how it typically goes 4 years and 1 year cliff. It can vary, depends on your circumstances, but it really does have to be there. And sometimes if you're too aggressive, and when you're founders, every once in a while I see people who say, look, let's vest them over 2 years, we're all so smart, this, that, the other. If you've gone 18 months and you get venture capital in, they're gonna say, go change your vesting schedule, revest your shares. I want to know that after I put money in the company, you're still going to be around. So don't try to get too cheeky with being too, having the vesting go too short if you're going to go out for external funding, because they're, they hire people like us who check the math and they say, actually, you should really push these people to revest some of their shares, because otherwise you don't know that they're going to be around. I'm going to very briefly talk about acceleration, because I want to talk about IP for a moment too, and then get a bit more to your question, Cecilia. Sometimes, or oftentimes, you'll see provisions in a restricted stock agreement that deal with acceleration of vesting, meaning what happens if there's an event that occurs while I'm not fully vested, where I really feel like in fairness, I should get accelerated. My vesting should zip forward so that I get all the rest of my shares vested, not just the ones that have already vested to date. The typical one you see is called double trigger acceleration. That means two things have to be true. You have to have gone through a change of control of the company, and you have to have been fired by the company but not for cause, or you have to have resigned for good reason, meaning the company's constructively fired you because the new owners have demoted you and slashed your salary and told you have no responsibilities and whatever else, right? That double trigger acceleration protects you, because it means that if somebody, if you do allow for someone to come in and take over your company and they decide, okay, they're going to get rid of you, you accelerate in all of your equity, and so you get to keep it all, right? The theory being, if you've added enough value and gotten your company to that change of control event, it isn't fair to rob you of the rest of the return you can get on that equity investment. Single trigger is more rare, right? That just means the second you have a change of control, instantly you get all your equity accelerated. It's less common simply because it sort of binds the hands of the company when it's talking about the deal value for the change of control, because sometimes, like after a change of control, the new acquirer wants you to still have some skin in the game. It just means they have to find another way to incentivize you, and oftentimes that comes out of the deal value. So it's just not typical to see single trigger, but I put it in there because sometimes folks ask because they read it on a blog or whatever. All right. Really quickly before we talk about founder PIAs, I want to talk a little bit more about your example, Cecilia, because it brings up some other concepts around value that I think are important. Pausing for a break for a sec. Okay. This comes up all the time. You have somebody who's going to start with your business, and it's not clear how their role is going to be, right? They might start as an advisor. Maybe, when I graduate, I might come full time, I might not. I might go back to second year school, and I might drop out. I don't know, whatever it is. The most favorable thing you can do for that co-founder is give them upfront the maximum amount of equity you can expect them to earn, out of the possible scenarios, right? Because remember, it's really good for them to have those shares immediately, get the fair market value at zero, right? So they pay very little for it, and start their holding period, right? So that's what's most favorable to them. So if you think, look, there's even odds, right? There's about 50-50 chance that you're either going to be full-time or maybe you decide to be half-time. You would, if you're trying to be as fair to them as possible, you give them their full-time share up front, but you use the vesting schedule to account for the fact that there's a decision point sometime in the future. So I've seen it done where someone says, look, we'll give you your full allocation today, but you don't even start vesting until the board has made a determination that you are working full time. And you want an objective trigger like that, something where they can't affect it or there's no argument. Either the board has acted and said, look, in a written resolution we've determined, Aditya is now working full time. Yes, that starts his clock. If you don't do that mechanical trigger, his clock doesn't start, right? And then he vests. And if the board doesn't decide that, or if they decide he's only going to be half-time, then he automatically forfeits X amount of shares, and only the remainder vest over 4 years in a 1-year cliff. Now, I've also seen it done where you have objective milestones, right? If the following things are achieved by the company by a certain date, then this person vests in these shares, otherwise they're forfeited. That can get a little more squirrely to negotiate because then you have to be really careful about defining it quite precisely. But the general principle is, from the perspective of the person who's holding the equity, that other founder, it's best for them to get more upfront. Now, from a company standpoint, if you don't think the odds are good that they're actually going to do the full-time job, right, your other option is you give them some of the equity today and you tell them, look, if you start in the future, yeah, we'll issue you equity in some form at that time, but it's going to be up to the board to figure out what makes sense because, I don't know, if you're telling me you might start full-time in half a year, a lot can happen in a business in half a year. We might find someone else who's better than you to fill the role. And if you're not here working, we got to hire that person. So I'm not going to bind myself to give you all those shares or make it hard for me to take them back. I'm just going to tell you, look, and it incentivizes you too. If it's like, hey, I'm going to decide if I'm going to be full-time or not. If you see the business going places, you better get on the ship because if I wait for 6 months, the fair market value of the shares might go up. Maybe we've had an investor come in and they've looked at the company and given us a term sheet. I can no longer buy them for a millionth of a penny. So restricted stock might be out of my reach. I might be in crazy, 10 cents a share world where buying a real percentage of the company is actual money out of my pocket and I'm a student. I'm not going to pay that. Therefore, I'm going to take an option at that point. Not as favorable to me. So it's a little bit of a mixed conversation around what you think the odds are of them going one way or the other. But you can absolutely solve for it in a way that, with all of this stuff, right? You're trying to conserve your resources early and spend them where it makes sense. The architecture of Delaware law and a restricted stock agreement typically will admit of a lot of different kind of simple variables can be used to great effect to account for most situations that we see. It's pretty rare you have to do something that's totally custom and drafted from whole cloth, partly because it's not usually worthwhile to pay for it, right? Fine, go out, get a bunch of investor money and have a really complicated exec comp thing for the first head of sales you hire when you have $50 million in the bank. Okay, go negotiate the heck out of that, that's fine. But spending a lot of money and time doing something super custom for founders, not usually worthwhile, particularly because you have pretty good options for how you can proxy for it, because vesting does a lot of that work. The company can always decide to get rid of somebody or threaten to get rid of somebody, right? Everyone kind of knows that that's in the background as a way of renegotiating or changing an arrangement. One more thing quickly on this before I talk about IP for 2 minutes. When sometimes companies will say, look, we all started out doing a third, but it turns out we have to add somebody and then 2 of these people are doing less, right? We have 5 people and we got to shift around how everybody's allocations work. There's a little bit of cap table jujitsu that you can do where because remember your percentages relative to one another are all that matter in a sense in the beginning, right? And because everyone's around the table voting because you all agree on what needs to happen, rather than saying we have to have people have crummy tax outcomes by issuing new shares to somebody when the fair market value has gone up or whatever else, through a mix of new issuances and forfeitures, followed by what we call a stock split, which is when you take 1 share and make it into 1.5 shares or 1 share and make it into 2 shares, you can arrive at an end result that gives you the relative percentages you want, typically only through forfeitures, right? So you don't actually have to issue new shares at a higher fair market value. So you can work with your attorneys to do that at the time, but suffice to say you can, before you have investors involved, doing a bit of rejiggering as long as everyone's around the table, you can typically find a tax minimal or kind of tax, kind of something with no tax effect, missing the word. It's kind of a way to do that doesn't kind of have any tax implication. Sound good? Okay, intellectual property. I know you guys do a whole other session on this too, but very, very briefly. This is remember that graph in the very beginning where we talked about the entities in the middle and everybody's got their little contracts with the entity. You've got your restricted stock agreement, right? That's the equity you get out of the company. But in exchange, you are contributing all the contents of your brain about your business to the company. So the stuff you came up with before and the stuff you come up with while you're working with the business. The IP agreement is vitally important, right? If you're when you found the entity, you need to make sure that every single person around the table signs something that assigns their IP to the company and commits that person to keeping company proprietary information confidential. Those agreements sometimes have a non-solicitation provision that means they can't try to poach employees or opportunities from the company if they leave. They also might have a non-competition obligation, obviously getting more and more rare over time as the FTC and a couple of states have decided, look, maybe we shouldn't have arrangements like this, but they're still permissible, so we still include it. And you'll also have some other covenants in there, how you have to put future employers on notice of your obligations to your past company, things like that. So read that carefully, but know that it is an essential part of any founding checklist. Getting back to that Clerky example, if you're going to go incorporate on Clerky, you have to remember it's not just about founding the entity and getting your shares. You have to also make sure that you execute invention assignment agreements among all the founders, each of you with the company, to make sure the company has the whole bucket of IP it needs to make its product. Otherwise, you're going to have to be chasing somebody 2 years from now if they've exited the business, right? And you're going to be a little bit over a barrel, which you don't want. One thing for you guys just to think about, probably not relevant to any of you because of where you sit, but it's possible. If you're going to have academic co-founders, people who are professors at labs or somewhere or postdocs, oftentimes, almost all the time, their institutions are going to have intellectual property policies that say, forget about whatever your company says. From where we sit, you're our full-time employee, so everything you invent is our property. So you will oftentimes have to feather in that concept into your invention assignment agreement if you have someone who is subject to an IP policy at an institution. Typically for founders at a business school, it doesn't matter, right? HBS doesn't purport to own the contents of your heads. This is like, oh hey, the person who invented this at their lab, who's the chaired professor of so-and-so at MIT, he or she, when they sign an agreement with the company, it's going to be a consulting agreement, and it's going to have a bunch of exceptions in it that say, look, MIT owns the stuff I come up with, you have to license it from them when I've made inventions. So it's just something to flag for you guys to think about. But it's absolutely essential that you have each of those elements, right? The equity, relationship with the founder, and then what they give in return, that IP provision, the provision of IP rights to the company, to make sure you've got kind of your whole suite of agreements all set. Okay, it is now 12:32. I'm 2 minutes over. I'm sorry for holding you. But I did budget myself an extra half an hour of time to go through questions and any extra comments or any extra topics folks want to talk about. So I will not be offended if you have to jump to your next thing. I will say thank you for being here and joining this session, and I'm happy to hang around and take questions and make sure, I missed 83Bs. You guys got a minute on 83Bs and we'll do questions? Yes, I see some nods. Okay, I'll do 30 screaming hot seconds on 83Bs. So when you take restricted stock in a company, you take it, what the IRS calls subject to a substantial risk of forfeiture, meaning you have the stock, but the company at any time could terminate you. So in theory, right, you don't really own the stock yet from the IRS's perspective. This is the super simplified version of why an 83B is important. And instead, the IRS says, look, when you start to vest in the stock, that is when it is no longer subject to a risk of forfeiture, right? Because you vest it and you keep it even if you leave the company. So the IRS, from their perspective, looks at you as receiving the stock at that future point when you vest. But you've only paid a millionth of a penny for it. So when you think about the logical extension of that, it would mean you pay $10 for the stock today. A year from now, you have a taxable event. 25% of that is now yours. You only paid a millionth of a penny for it. So the IRS asks the question, what is it worth now? And to do your taxes, you would have to do that calculation. Well, it's worth X, and therefore I've gotten a gain, I've received compensation to the tune of the difference between the millionth of a penny and what it's worth today. And oh, by the way, next month, I have to do the same calculation at the next month's fair market valuation for the little slug that vested that month, and so on and so forth, to the tune of all 4 years of your vesting. So it ends up with a totally absurd result, right? That you would end up owing kind of marginal additional taxes as the value of your shares increase over time, simply because they vest. And because you're probably not doing that because everyone forgets and it's a crazy thing to have to do, you accrue penalties on top of it, because if the IRS ever discovers it, they say, hey, you owe all of these back taxes for these 4 years that you haven't paid us over the course of this time. So not only do you owe us the tax, but there's a bunch of penalty on it. And by the way, if they construe it as company tax, meaning it's company, kind of company compensation in the form of stock because you're part of management, the company also has obligations to the IRS. They haven't been discharging. So it is a giant cluster is the term of art for it if you miss an 83B election. But the 83B election basically says, it's a one-page letter that says, hey, IRS, I got these shares. I paid a millionth of a penny for the shares. I know that they're subject to risk of forfeiture, but I'm going to pay the tax that I owe on the shares today. I'm just going to assume that, at my own risk, that I'm going to be able to vest in all these shares. And by the way, the tax is zero because I paid fair market value for the shares. And then this entire problem goes away. So it is at the intersection of the simplest, most low-cost fix possible that fixes the biggest downside tax problem you can bump into that's not really fixable. And so that is why when you have lawyers who draft these agreements for you, some poor first-year associate at our firm will be tasked with haranguing you every 2 days to make sure that you take it to the mailbox and mail it in, because that's how the IRS does it. Although I have been informed that recently clerking a couple of platforms have finally gotten the IRS to allow for an API so you can file it digitally. So assuming that's actually true and works, it's a much better way of doing it, because like getting people to use mailboxes these days is crazy. It's like you'd think that they're 50 miles away and they're not. But that's why it's so important, why we're so focused on it, because if you discover it later in diligence and you've missed it, it is one heck of a task, if it can be done at all, to try to pick apart the tax effect of it and mitigate it. You really just can't go back, because you usually pass the tax year. It's a big problem. So that's 83Bs in a very short nutshell. Please file them, they're important. Okay, I think I've hit changes in split over time, entity formation we hit, A3B we hit. Now it's time for some questions. I see Chris, you got a hand up, and then Kenny. Chris first.
Yeah, you had mentioned licensing technology from labs. I was curious what type of stock the principal investigators generally get. Like, say it's a PI, they are going to be kind of a scientific advisor.
Mm-hmm.
Would they have founder stock, or are they typically issued options for their involvement in like an episodic manner?
That is a great question, and I would say that entirely depends on how experienced and how big of a cheese the person is that you are talking about, right? If they are someone who is like a key opinion leader, well-known, named chair, this and that, and part of a bunch of companies, they're probably going to expect founder stock, restricted stock. And this is what we typically see. Like, I do a lot of spin-outs every year. Like, Bob Langer starts a company. Bob Langer and a group of people who are involved in the inventorship, right, they each get a small amount of founder stock, right, restricted stock from the very beginning, in exchange for a consulting agreement to make sure that over the course of time they are advising the company. Sometimes you'll have people who will get an option because you engage in a little bit later. And by the way, I also want to just say there's an implicit assumption in your question, just for the sake of the group. You don't have to give the PI anything, right? If you're some outside company and you're taking, you're going to go license from Harvard Medical School, some imaging technology, whoever developed it doesn't have to be part of your company. It's not a requisite. That person, the inventors and the patent, will get paid anyway through the university. University earns royalties. They usually distribute a little bit of it to the original inventor, so they're compensated. But to get the person's time and to get their head on your slides and their bio on your website and all of that stuff, yeah, you usually write them in. Because you're doing it at the outset of the company, it's usually kind of the fair and reasonable thing to give them restricted stock. It's usually a fairly small percentage too, so it doesn't really change the voting dynamics too much. But again, it depends on the person. People with bigger names can tend to be able to demand a bigger take of the early stock of the company. And you're typically doing it because you want them to know and love and prioritize you. And so they know that you can give them restricted stock versus giving them an option for a millionth of a penny. They also will typically ask for, instead of having the 1-year cliff on vesting, because the 1-year cliff almost serves as a proxy for like a trial period. Maybe this person adds value, maybe they don't. Because usually these people add value as of time 0, because their name opens doors, their head's on your slides or whatever, and like they make you a known entity as a company. They usually think of themselves as adding value, and therefore their vesting starts immediately. There's no cliff. So the difference for them between an option that starts vesting every single month for a millionth of a penny, where they could just exercise it by sending you 5 cents a month, versus giving them restricted stock, it almost starts to feel silly to them, probably, if they can be in that early. Later scientific advisors, yeah, like once your company's already established and you're like, oh, like we met these people at a conference, we're building out our SAB, those are usually optionees. That's typically how you would do it, versus kind of like founding PI, people who know the underlying technology super well.
Can I ask a quick follow-up?
Yeah, please.
What's the general range for a Langer-esque name? What would be the typical range they'd ask for in restricted stock options?
That's a tough one. I mean, because that can really vary. It's sort of like the most I've ever seen is 15%. I'll say that, which is high, right? It's a good chunk of the company. But sometimes it's like there's a consortium of people who have 15, and there's some other people who are more involved, and then there's like the CEO, the person with the real oar in the water, who has a slightly larger chunk. But 15 is at the really high end. Usually it's less than that. And the expectations, if you have 15% of the company, are pretty, like, they should be pretty high, right? I mean, that's like proper co-founder territory. You really need to be out there, like usually it's because these people can help you raise capital, because they can go to their book of people who invest in their companies and say, hey, check out these folks, they're spinning out this technology, I love it, it's amazing. And it really gives you a glide path That should be the theory anyway. Another thing is like, even though they're subject to vesting, you know you're very unlikely to actually terminate them. So you should think of the 15% as being gone, right? Like, like if there's some huge key opinion leader in your field who's the PI on the work, like even if the person's not picking up the phone that much, you're probably not going to terminate them, is my guess. So like doing a bit of diligence is helpful too. Like find other people who are founders in companies that they've been part of the group of, and like find out kind of what their deal was, how involved they've been, how helpful they've been when things have been difficult in the company. Because like people can be fair weather fans, but they can leave you pretty quickly if you're having a tough time. And hopefully you'll be able to get a sense of what kind of partner this person is, and that'll help inform your decision on it.
Cool. Yeah, thank you so much.
No problem at all. There's another hand over here, which I've now. Oh, there wasn't. Okay. Anybody else have other questions? Kenny, you had one. Sorry. Yes.
Yeah. So could you speak a little bit to provisions for and enforceability of like contractual terms for trade secrets? I guess my question comes from this idea that within software, it's like, it seems really difficult to enforce like someone not taking like a code base and just going away with it. Like I think that Tesla lawsuit is still happening right now.
Yeah.
And obviously there are like things in the early days you can do, which is like, oh, if I personally have built the entire code base, I can block some of it in private code repos. But at some point, once a company gets too large, you have to share that code with your employees. So I'm just curious in terms of, is it actually possible to enforce like protection of trade secrets within like code bases at all, or not really?
Yeah, that's a great question. I mean, this is a question that I want to broaden it to beyond code bases to kind of, this is a stump speech I give to every startup I work with, because typically I'm working with a smaller company that's growing. Even the companies who have like 300-400 people and lots of money, they're typically contracting with like multi-billion-dollar public corporations or like companies that are overseas or whatever else, right? So we're usually David and somebody else is usually Goliath. The answer is like, the best you can do is the best you can do. Having a really good contract and try to protect yourself is helpful, but it's not a panacea. It's not like you can snap your fingers and get a judgment and get assets back from somebody who has screwed you over by taking IP. It's hard, it costs money, and it's uncertain to litigate these things and to figure out that it's even happened and to know who to sue and what kind of discovery to ask for to try to figure out, okay, can I even get satisfaction from this company? So, or from this individual. So typically what I would tell clients, the best thing you can do is think about all different possible ways you can meet your underlying need. Your underlying need is to not have someone take your software code. That means an NDA is really helpful, right? Like hard terms that bind the person, bind the entity to not do certain things, to not disclose it to other people, blah, 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 all of that stuff, right? But that's just paper, that's just a contract. Operational stuff, right? To your point, it sounds like you're already thinking this way. Not just giving away the entire code base to everybody, making sure you have role-based permissions in your company, so only certain people can access the crown jewels. Carefully chunking out, if you're gonna, like all the time, like I work with a bunch of companies that do kind of vision and AI technologies that have applications to autonomous driving and cell phones and other like sensors. And all the time we have like some foreign company from another jurisdiction says, hey, we want to evaluate your product, like ship us your source code and we'll have our engineers evaluate it, right? You laugh, but sometimes founders are like, oh, like the deal sounds really good, like should we do it? We can have them sign an NDA. And I'm like, absolutely not, don't do that, right? There's an easier way to do this. Have them, you can even pay them to do it. Have them come over, send a person to your site and sit with them and have your engineers walk them through how it works, but don't literally give them the code base. See if you can accomplish the underlying need through something that is less exposure for you. So look, in the beginning, if you and 3 or 4 other people are jamming and working on a code base together and everyone's got access, it can be hard to police. If someone decides to pull up stakes and go somewhere else and they've just got a copy of it, you're not going to know that they're running it inside their system. But some of the things that keep people honest would be things like, if you do have an NDA with them and you've signed invention assignment agreements, right, at the very least, they have to live in fear that if it's ever found out or on their company's exit, right, if they go through an audit, right, that someone could figure out maybe this code base didn't come from you originally. And like, frankly, in order to get funded and go through an exit, they'd have to lie in all their reps, right? Or they'd have to disclose that, hey, we took this from some other company. So there's risk in them doing something that's kind of bad actor-like in that way, but it is pretty hard for you to on your own, enforce it merely by contract or even sometimes by operation in the beginning. You just gotta try to be careful and pick your partners well and rely on incentives too, to a degree, right? If they've got enough equity in your company and they're sticking around, why would they take the code base and run somewhere else? But look, you can't perfectly insulate yourself from it. But from a technical standpoint, just to answer your discrete question, yeah, like you can absolutely enforce a contract, right? That covers trade secrets. You've got statutory remedies too in trade secrets if they're properly protected. But as you point out in the Tesla case, litigation takes years, and it's uncertain, and it costs a lot of money. So it can be very hard to actually get satisfaction, even if you've got great rights under a contract, to actually see it through and get paid is tough.
Okay, thank you.
No problem. Any other questions? Yes?
I had one, but
Yeah.
I might have missed it.
Yeah, get me.
Lost signal, but Grace asked it in the chat. If you go to that co-founder breakup and you'd already formed an LLC, 2 of the 3 founders still want to work together, but the last one, we don't want to work with that person anymore.
Yeah.
It's basically her question.
Oh, sure. You mean LLC or Delaware C Corp? Doesn't matter. Well,
We started as a Delaware LLC. We're wrestling with, like, do we go form a new entity and shut down this one?
Okay. This is a complicated one. So let's pick through the facts really quickly. I'm going to assume here for sake of argument, you formed a Delaware LLC. Everybody signed agreements with the LLC, so now the LLC owns your intellectual property, right? The app or whatever it is you've developed, right? You have to look at your operating agreement, because Delaware law is not going to tell you what happens, what the rules are when someone leaves. Because I'm going to imagine for a moment that you've constructed your operating agreement similar to the way that vesting would work. No, you're like, don't imagine that. It's wrong.
Never constructed the operating agreement.
Ah, shoot. Okay, so you have no operating agreement. You have an entity. Do you have a certificate of formation or something? Anything that talks about who's got what rights?
Yeah, we have a certificate of formation and
do you each have equity interests that are clear in the company? I mean, like, have you written down in that document or anywhere else, like we all have a third or something?
33% each.
Right, but not subject to vesting. No. Okay, so like from a technical standpoint, you can't, unless there's something in an operating agreement that says you can buy this person out, right? Say your first path is, I think you check the Delaware LLC. Like, I don't know what the background rules are on this, right? Because all the time that we have an LLC, it's an operating agreement, it just trumps. But check the Delaware statute to see if there's any background rule on, in the absence of an agreement, what you can do if someone exits the business. Like, ideally, that would be great if there's something that's like, oh, you can do a buyout, at fair market value, which is going to be 0 or something like that, right? But like, I don't know if that's there, so check that first. Let's assume it's not there, and you've got nothing, right? And you're just kind of guessing. Like, it's not free of risk, but I would say probably start a new entity. Right, because it's you'd have to, and like the best things you can do to insulate yourself, right, is you have to, are you far along in the development of the IP or no?
We're about to be.
All right, so
we just got awarded a fellowship to have like 3 developers start building it.
Oh yeah, don't move.
Next month. Yeah, so we want to form a new entity before we build it under the old entity.
I might, yeah, because if you can think about it, the best you can possibly do, and I've seen this done, is you basically imagine that the old entity never existed. You chuck it, like you say, look, this entity has IP, but I'm not going to use any of it, right? It's gone. And you delete all of that IP from all of your systems. You don't look at it. Particularly, you don't show your new developers anything that the old company did. And you form a new C Corp and say, we're going to do something that is like a similar business idea, right? But we're not going to use any of the old code or any of the old wireframes. We're just going to have these new humans build it in a clean room, effectively. That gives you pretty good insulation against the claim from this other person that you're using IP that they have a right in, right? But like, it's hard to help you figure out the entirety of it in knowing you for 10 seconds and hearing the facts. Like, that's how I would start thinking about it, is like, what can you do to insulate and cause, put an air gap between what the old company has and what the new company is going to build to make you as certain as possible you're not going to catch litigation as a newco. Because you can't, unless you can buy out the other person and kick them out of the old company, you're in a bit of a tough spot. You don't want to be carrying them around. It's a pretty big drag on your equity. 33% of a non-contributor.
I may just try to get.
Is this person willing to just sign something forfeiting their equity? No, I assume no, or you would have had them do it.
Yeah, we would just like to just shut down the old entity altogether, not ever work on that entity, and then just start from scratch with 2 of us. But I may just get on your calendar. It seems like I may have to give you more facts and details.
Yeah, bug me for sure, because that the best thing you can possibly do in any of these situations is like get the other person to sign something that makes them so they can't sue you in the future. Because like everybody's chill today, but if you become a $1 billion company, like at Thanksgiving one year, their uncle who's a lawyer might be like, hey, like, I saw these guys, wasn't that the thing you did? Like, you should, so, you never know. People get funny when somebody else makes a lot of money on their idea, or they think they do,
Thank you.
Yeah, no worries. Anybody else? And we're waiting a couple of minutes here? Yes, Kenny.
This has been a really good session. Hope you don't mind all the questions.
No, not at all. I like talking about this stuff. That's why I'm here. So please shoot.
So I'll co-ask this question. So Grace and I are working on separate ideas, but we were both just chatting about this idea of how early should we get people to sign NDAs? Like, we have prototypes. We're showing people we know, and we say, don't screen record, don't share. Should we try to make them sign NDAs this early, or at what point should we actually start doing that with our prototypes?
That's a great question. This is one of these like EQ relationship judgment questions where like the technical answer is, yeah, everybody should sign an NDA, right? Because you always want to make sure that like they know it's serious, they're not going to share it with people. But like the real world doesn't work like that. And you're going to piss off all your friends if you make them sign paper first. If it's sort of more in this kind of chill, trust relationship. So I think I think it's more important earlier in time to get things signed with people if they're contributing to intellectual property. So I want to make that distinction. Like if you're doing a jam session with a bunch of friends where you put your app up on the whiteboard and you say, help me solve this coding problem, and 3 of them contribute to the solution, you should probably have an IP assignment with those people, because if you're going to be serious and be a company, like you want to make sure that you've got that locked down because they're contributing to the product. If you're like, test this and tell me what doesn't work for you, or tell me what you like or don't like about the interface, that's sort of softer IP, I would say. You can probably get away with saying, look, just do this as a friend. And if you trust them enough not to try to scoop your idea, or if you're showing them stuff that's not like the crown jewels, you're probably okay with that on NDA. At some point, though, you're going to start, like, I think where it gets to be more formal, there's not a trusting relationship involved, it becomes more important to have an NDA before you show somebody like core product stuff. But look, I mean, if everybody who showed everybody their products and ideas in the iLab signed NDAs with everybody else, you have a stack of paper, nowhere to walk. So there's a little bit of like, you got to be like, I think you're right. You got to be practical about this kind of stuff. It's gonna, it's gonna alienate people if you're too pushy about it. You just have to. It's a bit of a judgment, right? It's a bit of a judgment. So that's the best I can give you.
Okay, that's great.
Like the lawyer answer is like, get everybody to sign something, right? But it's just you can bear a little bit of risk with this. It's like VCs. Not all VCs will sign NDAs, right? Many of them don't. And so you just have to, trust that they're repeat players and they're not going to screw companies. But like sometimes they do, or they inadvertently do. You bear some risk by just making a call. It just is what it is.
Okay. Really quick follow on. So when you're
Yes,
selling to enterprises,
sorry?
When you're selling to enterprises or doing like demo with like people who are not like close friends, like you can't make them sign an NDA, right? At that point, like if you're trying to sell to enterprises and you're showing them the product, there's no way you can.
Oh, for a product demo?
Yeah.
Probably not. I mean, it depends what the product is, because like at some level, like the product demo, if you're tracking to be like a SaaS company or something, you're probably putting a demo on your website at some point in the future. So you're probably not you're not showing them something so proprietary. Like you almost like you want them to tell their friends, hey, oh my God, look at this interface, it's amazing, or like look what the functions can do. The NDA comes if you're doing an enterprise partnership and you're showing more than just the demo. Like sometimes big companies want to see your financials or your business plan. And like, yeah, you want an NDA for that? Because they're like, look, I want to do diligence on you and know that I'm getting in with a partner who's going to be there, right? Not atypical. It's like some of that kind of stuff, sure. But like just pure product, as long as you're not showing them like the crown jewels or the guts. And it's also a question too of like who the counterparty is. If you're selling to Amazon, yeah, you want them to sign an NDA because they have a team of engineers they could just opt to build your company tonight if they want to. Like if you're selling to people who are not expert in what you're doing and couldn't imitate you, it doesn't matter quite as much, I don't know. That's my thought on it.
Great, thank you.
Yeah, Ali, you have a question?
Yeah. So throughout the session, we've been talking about different types of documents, whether it's like NDAs or for example, you're trying to safeguard like your code base and so on and so forth. If we were to engage a lawyer every single time we're going to have to do that, we're probably running out of money. So my question is, where would we probably find these documents? Like, would I like? Because I know Clerky or like Stripe Atlas, like that's what I use to incorporate. But when it comes to other types of
no, you need. I mean, here's like the real deal with getting a startup lawyer is. All of us in the industry, we recognize we have to take risk, right? So everybody does a deferral program, and everybody's got their own custom brew forms and a package they make available to companies. Like when I work with a company out of HBS, and like I do a lot of it, like the company will sign on with us if they kind of pass our internal diligence process. We will help them incorporate, and then when they ask us for forms of whatever NDA, material transfer agreement, pilot agreement, we just hand it to them. Like it can, we'd say, look, take this and you can play with it and think about what you want to tweak, and we'll look at what you do, and however much you want us to engage, we can. But very importantly, almost all law firms will put you on a deferral program anyway, so you don't you don't have to actually pay lawyers to do stuff until you're funded, typically. And like the kind of a usual early case for this kind of stuff is like, you spend a bit of money that you don't actually have to pay for, but like you kind of run up a bill a little bit for, incorporation, negotiating anything you need to tweak in your restricted stock agreements. Like you're just gonna get handed forms of NDA from people, but like you're not gonna negotiate them usually with some counterparty. But like your very first material transfer agreement, if you've got like, you're a battery technology company and you want to send your, battery can to somebody who's going to go see if they can make, do this or that to it, right? Like that's usually negotiated, but it's not a huge amount of money typically. And it's important because IP is at stake usually, and you'll have the lawyer do that. And then, that sort of goes on the heap of the legal bills. And then once you guys get funded, you pay for that work eventually. But it's not like every single time you sign an NDA, you have somebody review it. I mean, it's usually your form. And if somebody makes tweaks to it, it's very quick to review. Like if when we give a form of NDA to somebody and somebody comes back with a markup, like I can get through that in like 3 minutes and just tell you, okay, here, this is what they did. Like, are you comfortable with that or not? It's not like it has to be some huge, 2 hours worth of markups and negotiation. Like it's an NDA, for God's sake. Like everyone's wasting time and money. In a startup context, right? In the Amazon context, Kenny, though, like if you're going to do, like I have spent a lot of time helping a client negotiate very carefully an NDA where Amazon might have acquired them. And so they were giving really deep diligence access to the product. It was a developed product already. So that was one where like, yeah, we went back and forth a bit because it was on the cusp of an exit event and like there's a lot of money and value at stake. Very different than like, oh, you're gonna see my alpha product demo. Like, you don't always do an NDA for that anyway.
Understood. Awesome.
Yeah.
And so I guess just like kind of like a quick follow-up to that, with that, with I guess typically with the clients that you see, startups and so on and so forth, do you start that relationship after incorporation, before they incorporate? What, like, if have you ever had a startup that incorporated then engaged you guys?
Yeah, all the time. I mean, we have startups that incorporated on Clerky and come to us. We have startups where they come to us before they've incorporated and we help them do it. We have startups who have engaged another law firm and haven't been happy and moved to us. They've done a financing event and moved over. Like, you can hire some new lawyer at any time, right? And typically, if when you engage a law firm, they'll look at whatever you've had before off the clock. They'll just say, look, like I just want to understand what's happening with the company, and you'll identify. Like if you incorporate on Clerky and you all forgot to sign a bunch of invention assignment agreements, that's like red flag number one. And they'll say, here are our forms. Please sign these. We've dated them as of the date you guys started, because you can do some. It depends. It is context dependent. You can do a kind of effectiveness backdating for certain types of forms, just like clean up your IP situation, and then we'll go forward. But yeah, I mean all the time. And look, if you guys are any promising company, some law firm isn't going to turn away because you're already incorporated on Clerky. That'd be ridiculous, right? It's like you got to meet people where they are a little bit, And also, and picking up on something you also said about expenditures and NDAs, and I've got to cut because I actually have a 1 o'clock call. Whoever you're working with needs to help you be an intelligent collaborator with your legal partner. Like it is super unhelpful for you as a startup if you tell somebody, hey, I have an NDA with so-and-so counterparty, and they run up like a 5-hour bill marking up an NDA, or I'm picking a silly example, right? Like they have to help you by asking you questions and really targeting and being practical about what's going to make it like a real difference to your company, instead of just going off and putting together a bunch of things that result in a legal bill. Like it's super unhelpful to you if that's the approach. So like you should be consciously selecting for that in an early partner if you're going to bring somebody on, because someone can give you a bunch of forms and then whatever, hand you off to your junior associate that's going to spin wheels a lot and like get you a bunch of stuff that's not really that useful, or like overcook the goose and send you a bunch of memos on things that are not helpful. But like you really want somebody who works with startups a lot and gets that you got to be kind of 80-20 about stuff and help people take risk intelligently, instead of just like, oh, here's a gold-plated answer. Like that's super unhelpful. Nobody needs that. So anyway, you got to find someone who lines up with your approach.
Thanks.
Cool. All right, I'm sorry I have no more time for questions. If you have anything extra, I think you guys can get, well, I probably have it on a slide. You guys can get my information from the folks at the Rock Center if you want. You want to sign up for office hours, or even if not, if you want to just email me, I'm happy to talk anytime. You guys have been great. I really appreciate it. It was a fun time. Bye all.
This was super helpful, Alex. Thanks a lot.
Hey, it's my pleasure.
Thank you so much.
Thanks.